All right, let's try this again. Good morning, everyone. I'd like to call to order the Judiciary Committee public hearing for Monday, April 25, 2022. Before we begin, I'd ask the Vice Chair to read the safety instructions.
Morning, everyone. In the interest of safety, I would ask you to note the location of and access to the exits in this hearing room. The two doors through which you enter the room are the emergency exits and are marked with exit signs. In an emergency, the two doors behind the legislators can also be used. In the event of an emergency, please walk quickly to the nearest exit. After exiting the room, go to your left and exit the building by the main entrance, or follow the exit signs to one of the other exits. Please quickly exit the building and follow any instructions from the Capitol Police. Do not delay and do not return unless and until you are advised it is safe to do so. In the event of a lockdown announcement, please remain in the hearing room, stay away from the exit doors, and seek concealment behind desks and chairs until an all-clear announcement is heard.
Thank you, Representative Blumenthal. All right, on our agenda today, we have various nominations for judicial branch appointments from the governor for review. First up will be the Honorable Joan K. Alexander of Cromwell, who has been nominated to be a justice of the Connecticut Supreme Court. Judge Alexander, if you could raise your right hand for me. Do you solemnly swear or affirm that the testimony you'll give to this committee will be the truth, the whole truth, nothing but the truth, so help you God, or on a penalty of perjury? Great. You can have a seat. Feel free to take off your mask if you're comfortable doing so. And if you have an opening statement, you can proceed. Judge, in front of you, there should be a little button. The microphone needs to turn red. There we go.
Thank you.
If you could just pull that a little closer to you so we can hear you. It's adjustable.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and other distinguished members of the Judiciary Committee. My name is Joan Alexander, and I am humbled and honored to appear before you today. At the outset, I would like to express my sincere thanks and gratitude to Governor Lamont for nominating me to serve on the Connecticut Supreme Court. In addition, I owe many thanks to the exceptional people at courthouses all over the state who have helped me in countless ways to fulfill my responsibilities as a judge. It truly has been a blessing and an honor to work with such talented and dedicated individuals for over 20 years. Finally, I would like to remember my parents today. My father was a tool and die maker, and my mother was a school crossing guard. They had an immeasurable impact on my life by instilling in me a strong work ethic and the importance of respect, fairness, and integrity in all of life's endeavors. Neither of my parents went to college. However, both of them emphasized the importance of education and the responsibility of having a positive impact on our community. I wish that my parents were here today to see this, because I am certain that they never imagined that one of their children would be asked to serve on the Connecticut Supreme Court. I would briefly like to tell you about myself and my background. I'm the youngest of 3 children, and I grew up in Bristol, where I attended public schools. I was accepted by Yale University as an early admissions applicant and graduated with a Bachelor of Science degree in mechanical engineering in 1984. I then attended the University of Connecticut School of Law and received my Juris Doctor degree in 1987. Currently, I live in Cromwell with my husband, who has always provided me with his unwavering loyalty and support. After my graduation from law school, I served as a prosecutor for the state of Connecticut for 12 years, during which time I tried murder, arson, and other felony jury trials. In March of 2000, I became a Superior Court judge and was primarily assigned to criminal proceedings from arraignments to jury trials. In addition to my courtroom assignments, I served as the Chief Administrative Judge for the Criminal Division, the Chair of Sentence Review, a member of the Jury Selection Task Force, and on numerous other judicial branch committees. Since becoming an appellate judge in 2020, I have heard over 200 appeals and authored 40 opinions in all areas of the law: criminal, civil, juvenile, family, as well as administrative appeals. My undergraduate studies in engineering have helped me as an appellate judge and really throughout my career to write opinions that are analytical and precise. An appellate opinion often becomes the roadmap for litigants to structure their legal arguments at trial and for a trial court to use in its judgment. If confirmed, I will bring to the Supreme Court my knowledge of both these trial court proceedings and appellate review. I recognize the importance of being fair and impartial. I believe that I can work with the other justices in a manner that honors and respects the law and provides for unambiguous and understandable legal authority in our state. After your consideration of my personal background, as well as my experience as a trial attorney, a superior court judge, and an appellate court judge, I hope that you will find me to be qualified to serve on our Supreme Court and approve my nomination. Thank you again for this opportunity to appear before you today, and I welcome any questions that you may have for me.
Questions from committee. Senator Kissel.
Thank you very much, Chairman Staffstrom. Your Honor, great to see you again. Congratulations.
Thank you.
I've had an opportunity over the years to work with engineers, and I think I frustrate them a little bit by being too, I wouldn't say wishy-washy, but not as precise, looking for more of a 30,000-foot observation. And I appreciate your testimony this morning indicating that it's actually a very interesting bachelor's background that you have. And I'm glad that you pointed out that over these, oh gosh, if you started around 90, 32 years, that it offered you an advantage in drafting your opinions. Not that other folks that have more of a literature, history, poli-sci kind of background don't have that. I guess the one question that I have, and you've been before me in this committee any number of times, because I've been lucky enough to be able to do this for the last 30 years. But now that you're going to the Supreme Court, and I have no doubt about your confirmation, and I would commend Governor Lamont on selecting you, because I think you're an excellent nominee. But just for my constituents' sake and the folks out there in Connecticut, how would you describe your judicial philosophy? And I guess the key question is, would you go behind the statutes and look at legislative history? The whole idea of the state and federal constitutions being living, breathing documents. And along those lines, for example, with the notion of cruel and unusual punishment, back in the day when Justice Palmer was coming up for his renomination, he said, there is a perfect example of something that back when you look at the time of the framers, types of punishments that were meted out would not be acceptable in today's society whatsoever. And not the least of which is death penalty, but we had all sorts of things back in the colonial period that we just wouldn't even countenance today. So that's one aspect that just per force clearly lent itself to, some people would call it evolutionary change, but I don't know if some people would characterize it one way or another. But I'm just wondering what kind of philosophy you'll bring to the Supreme Court as you work on your first decisions and hearings.
Well, I think my philosophy is very moderate. I think that I take a careful approach to legal issues. I think that the Constitution has embedded principles that are timeless, such as people are free from unreasonable searches. That doesn't change. I think that, again, analyzing statutes that this body passes, it's important to just look at the plain language. I'm not going to legislate as a judge. I'm going to look to your legislation to its clear and plain meaning and apply the law. I think precedent is important, and I think it's important really for the trial judges and the litigants, because I think that they should expect to have some consistency from reviewing courts. And I think that our analysis finally needs to be thorough and, again, very much attached to the Constitution, the laws, and our precedent.
Well, I know there's others that want to ask questions, and we have other nominees today, but I'm really happy for you. I'm very excited about your nomination. I've watched your career, and I think you're an excellent jurist. And again, I commend Governor Lamont on selecting you to our state Supreme Court, and I just have no doubt that you're just going to do a wonderful job. And again, congratulations. Thank you so much, Chairman Staffstrom.
Thank you, Senator Kissel.
Thank you, Senator Kissel. Chairman Winfield.
Thank you, Representative Stafford. So, good morning, Judge Alexander.
Good morning.
I know that you are aware that there are some concerns that have been brought before the committee. Considering where we are potentially going to place you, I think it's particularly important that we have a discussion about the concerns. This process is one where you get to present to us before the public does. And sometimes when that happens and there are concerns, then the leadership of the committee is scrambling a little bit to figure out how do we address the concerns that were addressed to us post the testimony of the person who's in front of us. So, this involves a case when you were a prosecutor back in 1997. And I think it would be helpful for this committee because I believe that people will be testifying if you would talk to us about your actions during the case, a little bit of the history and what it means for us as we sit here. So this is an opportunity to do so.
25 years ago, as you've indicated, Senator Winfield, I was a prosecutor in Hartford. In 1997, Corey Turner and his brother Charles were tried for a 1995 murder before a jury. Each of those individuals was represented by counsel. Judge Koletsky was the presiding judge of that jury trial. After trial, both men were convicted by the jury, Mr. Turner of murder and his brother of accessory to murder. Mr. Turner's conviction has been subject to repeated and thorough claims and reviews of his claims of error. No court has found any of these to have merit. First, in 2000, his conviction was affirmed by the Connecticut Supreme Court. Since the Supreme Court's decision, Mr. Turner has taken 9 appeals to our appellate court, and 18 different appellate judges have reviewed his various claims. None of those appellate panels have found any merit to these claims. In addition, he has pursued 6 habeas corpus petitions and numerous post-trial motions, including a petition for new trial. As a result, 9 additional Superior Court judges have reviewed the evidence from his conviction. All of those courts have found his claims, again, to be without merit. Aside from the state review in 2009, Mr. Turner had a federal habeas trial regarding his murder conviction. After review of the evidence, Judge Shotney affirmed his judgment, and the 3-judge panel on the Second Circuit reviewed the federal court's judgment and affirmed his conviction as well. Since 1997, 13 different prosecutors and 5 additional defense attorneys have been assigned to review his claims of error in the evidence. I respectfully submit to you that the evidence in his trial, including the evidence he presents to you today, has been repeatedly scrutinized for error, and no courts have found any. As a prosecutor and as a judge, I believe in a thorough review of a conviction, and if a mistake was made, it should be corrected. Since Mr. Turner's conviction, a total of 37 judges and 18 attorneys have analyzed and reviewed his conviction. None has found any error. I recognize that murder trials are painful, they are devastating, and they are heartbreaking. Mr. Turner and his family believe that his alibi should conclusively establish he is not guilty. The court record, including these claims surrounding his alibi, an extensive review of that record, however, supports the jury's findings of his guilt beyond a reasonable doubt. I would just say that a murder is a lose-lose occurrence. The victim is dead and his family visits a grave. The defendant, if convicted, is removed from society and his family visits him in prison. It is an extraordinarily tragic result, and it has never been lost on me, nor ever will be.
Judge, let me follow up on that just a little bit. So your role in this 1997 case was as a prosecutor, not as the judge, correct?
Correct. Yes.
Have you ever sat as a judge on any of the hearings involving Mr. Turner?
No. In fact, as a prosecutor, when you finish the jury trial, you hand your file and everything associated over to appellate prosecutors, to habeas prosecutors. I would never involve myself in anything because I would want his review to have absolute integrity and have no, again, inference from myself as to what the result should be. What the result should be is what's fair and correct. And I have never been involved since 1997.
So no involvement with this case in the past 25 years.
Correct.
I've looked at some of the materials that have been submitted over the weekend on this, and I understand there's an issue as to credibility of the testimony of a potential alibi. Was there other testimony or evidence that was also introduced?
Yes. And I think that's, again, an issue that I understand why they're raising it, because if I was Mr. Turner and his family, I would want everyone to put credit on the alibi. But I think that's overly simplistic because the trial had a lot of evidence that pointed and established his guilt to the jury. That evidence included the victim, Mr. Woods, who had been shot multiple times and was in the process of dying. He died at the hospital, saying that Mr. Turner shot me. He used his nickname at the time. It was Boku shot me. And that was heard by several witnesses who were tending to him as he was expiring. There were eyewitnesses who knew Mr. Turner, who saw him commit the murder. His brother was identified at the scene and identified as picking up Mr. Turner a few houses from this shooting. And this trial's evidence, the state's evidence that I presented, was subject to cross-examination by two defense attorneys because it was a joint trial. So it wasn't just Mr. Turner's attorney who was attacking the state's case, but Mr. Charles Turner's attorney was attacking the witnesses and what they saw and what they heard. And so I think, and obviously reviewing courts have found that there was sufficient evidence to establish the guilt that the jury found.
Judge, just real quick, so on the testimony of the victim at the hospital, was that considered a dying declaration under the Code of Evidence?
Dying declaration, spontaneous utterance, yes. And those, again, in my experience, are extremely compelling. It wasn't at the hospital. It was actually immediately after he had been shot because there were several individuals around. And I remember one witness being extremely traumatized by having Mr. Woods basically expiring in his arms. He didn't die at the scene. He died later at the hospital, but he was very traumatized and did testify that those were his words. And again, our law recognizes the importance of those types of statements because they really, a person in that situation is not likely to name someone.
And with respect to the alibi, who was the arbiter of credibility with respect to the alibi?
It would have been the jury. And again, this was an alibi that was disclosed after the state's case had rested. Our rules of court, not that they, they allow for exceptions. The notice was submitted more than a year in advance, and only after the state's case had rested did they notice of the alibi. There were tape recordings of Mr. Turner and the witness discussing the points of the alibi. They were introduced, they are available, and with respect to it, there were certain things that came out of the alibi, again, that were for the jury to consider, including the alibi witness acknowledging that Mr. Turner had a gun. And so it's very difficult to put into a box everything about this trial, and that's why I continue to believe that the jury was in the best position to decide what to believe and what not to believe. And I also believe that reviewing courts like the Supreme Court, like the Federal District Court, like habeas courts, who pull apart all this evidence that is all there and available, really are in a good position to determine whether or not something went wrong. And I'm not saying the system is perfect, but what I'm saying is everything that is being raised today is there. It was always there, and it hasn't suddenly discovered like new forensic evidence. I've had cases where DNA testing takes place, because I guess I'm old enough that we were doing the simple blood test of A, B, and O. Subject those pieces of evidence to DNA test, because we need to keep making assurances that the system can do things right. If there's something wrong, I am a firm believer that it needs to be corrected. This evidence, though, has always been there, and again, subject to very extensive scrutiny.
Thank you, Judge. I think we can all agree the system is not perfect, but is the system of justice, the adversarial system of justice we have, and certainly, in this instance, you were representing your client, the state of Connecticut, as the prosecutor in the case. And it was 25 years ago. What I think we need to focus on as a committee here is more on your body of work as a judge over the last couple decades, in terms of what your qualifications to sit on the Supreme Court. So what I'd like to ask you about next is when you left the state's attorney's office. And we hear this all the time, and I know actually we have a class of Superior Court judges we're going to hear from later today, several of whom are coming from the state's attorney's office. How do you put that prior role aside as advocate as a prosecutor representing the state, to being a neutral arbiter as a judge? How did you make that transition as a Superior Court judge? And what do you think about that experience sets you up for elevation to the Supreme Court?
Well, in the beginning, and I used to nollie cases by mistake as a judge because I was so used to, that was one of the roles of prosecutor. Oh, the case is not being prosecuted. And the prosecutor would look at me like and say, Judge, you can't nollie the case anymore. So it's a little bit of a transition. I think, and again, this has always been my view as a prosecutor, that yes, we were the state's attorney, but more importantly, we were there to do what was right. And nollying cases is just as right as prosecuting cases because you're showing fairness and discretion, you're analyzing evidence, and you're giving a person the benefit of the doubt. There's a reason in criminal cases why it's the highest standard of proof, because it shouldn't be done again just to say I'm working for the state. It should be done because it's the right thing to do. As a transition to being a judge, I think that was a good background. Just like I think, my father being a tool and die maker, me being an engineer, you have to put in objectivity into this because it can't be driven by the result. It has to be driven by fairness, by consistency, and by applying the law. And I think that's something I've always tried to do throughout my career. I love being on the appellate court. Everybody thought, oh, she's gonna miss the trial court. She was in as a trial attorney. She was a trial judge. I love the appellate court. It gets you to have lively, spirited, thoughtful discussions about what happened in a case. It gives you time to actually look at every aspect of the record and make sure it's right. And I think that it is such a tremendous honor as well as a tremendous responsibility. I can't think of any better system that we have and any better way to conduct our review. And I'm just, I am very excited and humbled by the opportunity to perhaps participate on our Supreme Court.
Judge, one of the things we've heard kind of over the years on this committee is that oftentimes prosecutors, when they get elevated to the bench, are sometimes the harshest critics of other prosecutors.
Yes.
Do you believe that to be accurate?
It certainly can be a factor because, again, everyone walks in their own shoes. And so, you bring with you your knowledge and experience of how a case or which way a case should be handled. So I think that, you try to step back. And I think, again, one of the most important things, the transition that needs to be made is the ability to listen. And it's another reason I like being a judge. I don't have to talk as much as I'm talking here now. I like to listen and try to find out, what's going on. And, I had pretty, consistent style as a pretrial judge. I asked the state, what's your case? I'd ask the defense, what's the problems? What do you want? And what are you looking for? And so there was this back and forth so that I could understand and hopefully reach a just resolution.
Well, thank you, Judge. I guess that's one of the advantages of being a politician is when we get tired of talking, hearing ourselves talk, then we can finally listen. But anyway, with that, Representative Fishbein has a question.
Thank you, Mr. Chairman. Good morning, Judge Alexander. I also congratulate you on your nomination to the Supreme Court. Judge, listening to you talk about appellate being on the appellate court, I have to share that I've been there, I think, 12 times, and every time I just love it because, you're there to talk about a case. You can go to a restaurant and talk to your buddies about a case that you're involved with, but when you are speaking with very learned individuals who, have knowledge of the law about a case that you were immersed in many times over a year or so, I very much enjoy it. So I can see that you too enjoy that exchange and review, and I appreciate that. In fact, when I was reviewing the backup, that sort of jumped off the page at me. So I can tell that, but I specifically want to focus on your questionnaire. The third question, it has to do with interpreting the Constitution.
Yes.
Okay, and certainly I agree with original intent. But my question, does the supremacy clause of the U.S. Constitution still exist?
I think it does.
Well, I guess it arises in this building, we sometimes pass laws that, like legalization of marijuana, right? Marijuana is illegal under federal law. And, the supremacy clause would say that a state, in fact, no court anywhere in the country has found that action by a state to be lawful. So am I to glean from your answer to this question about original constitutional intent that you do believe the supremacy clause still exists and it's not a living, breathing part of our...
Right. Living, breathing, again, maybe from my technical background is a little too movable. I think that you have to look at language. I think like I said, statutory language, I know, and with all, you passed the plain meaning statute, to me, that was always embedded in the principles of law. You should follow the plain meaning of a statute. You should look at it in the context of the statute. You should look at it in the context of precedent. So I think that, again, original intent is a primary factor, but it's couched in terms of all those other principles as well.
Understood. And then the second portion of your answer, and I'll read it so that the courts may balance original intent with societal advancements in the areas such as technology. And I know that technology in the context of the First Amendment we talk about, because the internet, certainly the founders never envisioned the internet.
Correct.
Are there other areas of technology that you think that precedent or that rule would apply?
Well, yes, in criminal courts, again, that's very, again, evolving because, and even in one of my appeals, sales, in a Miranda case where someone invokes their right to counsel or invokes their right to remain silent, and then the police say, well, give me your phone. So the right has been, requested, but then the police seize the phone. The seizure of the phone is not considered a violation of Miranda, and so that phone can still be admitted into evidence. Courts have started to look at that as, is this really a violation of Miranda? Because a phone's no longer that simple physical object that it was. So the phone had generally been analyzed under Fourth Amendment seizure, but now it is being pursued by attorneys and, debated as to whether or not it's a Fifth Amendment violation. So I think that those kind of things, again, involve technology because, it's not the party line that we used to dial. And again, I must be aging myself, but, when the whole street had one phone line, it's not that phone line anymore.
I guess we're certainly concerned in the context of a smartphone, the text messages.
Correct.
Yeah. So, well, I thank you, and that's all I had. Given the other question, well, no, I had another. Your appointment to the appellate court happened when?
In August of 2020.
And at that time, was there any complaint about what Chairman Staffstrom was asking about here today?
No, this is the first time.
Okay, that's all I had. Thank you. Thank you, Mr. Chairman.
Thank you. Senator Anwar. And Judge, he is remote, so he'll be on the screen behind you.
Thank you so much, Mr. Chair. Thank you, Judge Alexander. Congratulations on your nomination. I just wanted to ask you a couple of more questions about the case 25 years ago. It is my understanding that you had been against the telephone conversation recording to be shared with the jury or the judge. Could you just explain to me why? Because again, it's 25 years ago, but that may have changed certain aspects. And why were you objecting to that?
Um, this the trial took place where the state, myself, put on the evidence of the factors in the case. The defense then introduced their witnesses, which I cross-examined, and I cross-examined them on those tape recordings. Then the state is allowed to offer rebuttal, where I offered evidence that contradicted that. After all of the case was done, the defense wanted to introduce, after the state's case, the final part of the trial, these tapes. They had been available throughout the throughout the trial, and the court ruled, and the Supreme Court found that they did not change anything in all of the evidence that had been presented. And that's why they were not admitted, because they were actually being asked to be admitted after the end of the regular portion of the trial, and they had been played during different parts of the trial. So the court found that they had been, in fact, enough in front of the jury, and I hope I'm explaining that right, but all of this was evidence that the jury was able to consider, and they did. The court found that it was not necessary. And that's what was reviewed also at the Supreme Court, whether or not those additional portions of the tape were necessary. And everyone had decided that they were not. They were consistent testimony with what the witness had said. And
So,
I'm sorry that you have I don't know if I should be facing this way or that way.
I think face towards the camera.
Okay.
Towards your right. Yeah.
So I can't see you. That's the okay. So I know I took a long way to get there, but what the witness had testified to was on the tapes. It had been subject to cross-examination, and the court ruled that it wasn't necessary to put the tapes in because the witnesses had already testified to those facts.
And Judge, I know we wear sometimes different hats, and we are trying to do justice with the hat that we are wearing. Now, if you were the judge, obviously this is hypothetical, but if you were a judge at that time, would you have not liked to look at all evidence that was available to make the best decision and make sure that the jury had access to all evidence?
Correct. I would want that, but again, our evidence is done by the witness themselves. So that's what the jury is asked to look at. And so if you had a tape recording that said exactly the same thing that you said in court, we wouldn't allow that to keep coming in, because the jury is asked to look at the witness, to size up that witness and determine whether or not what they said is true. So again, based on our general principles in law, our preference is to have the witness available for the direct examination, what the defense wants to bring out, and for the cross-examination by the state. The defense is then allowed to rehabilitate their witness, and a tape recording is not necessarily considered the best evidence. But I want to emphasize here that that tape recording was available to the court, and the court, the state, and the defense all had it available for them to listen to, and it still remains available, and it still hasn't risen to the level that Mr. Turner and his family would like to believe it to be, and that is that it conclusively establishes his not guilt. Because again, and I go back to it basically fails to take into account any of the other evidence that the jury was able to see.
I wanted to thank you for your responses and congratulations on your nomination. Thank you so much. Thank you, Mr. Chair.
I keep going back and forth.
Thank you. Yeah, the setup here is a little awkward, and CTN will only show the person speaking at a time, so that's why your face will show up on the screen. But we'll make do. The era we're living in, right? Further questions or comments from the committee? Representative Blumenthal.
Thank you, Mr. Chair, and good morning, Judge Alexander. It's nice to see you, and congratulations on your nomination.
Thank you.
Most of my questions have been addressed by other members of the committee, so I'll try not to belabor these too much. But just for the clarity of the committee, in terms of this specific case we were just discussing and the recording, was any part of the recording actually played for the jury in the trial?
I can't remember. I apologize, but when I stopped that case in '97, that's the last I've ever seen or looked at it, so I can't tell you. I'm sorry. I know the tapes. I remember listening to hours of tapes getting ready, and they are available, but I don't know if they were played or not.
Okay, but at the time of the trial, they were available to the defense, the judge, in addition to the state?
Yes.
Okay. And again, this is probably a lot for you to remember 25 years later, but do you remember on what basis you opposed admitting them into evidence? In addition to the timing, did it have something to do with them being a prior consistent statement?
Correct. And I didn't know if I should get into that technical, but it was being offered as sir rebuttal. I know as an attorney. So that means it's basically past the regular trial, and it was being offered solely to bolster their witness. But they had rehabilitated their witness during their defense case. I mean, people always say, and you're not lying, and you wouldn't come into court and lie. So a lot of the claims that they said or are alleging, I think were addressed. But again, if you pull out one thread, I don't think it gives you the entire circumstance of the trial.
Okay, thank you for that answer. And one more question on this subject. In your experience as a lawyer and as a judge, is that rule and the rules of evidence around prior consistent statements one that's exercised pretty regularly? Lawyers seek to exclude prior statements for some reason or another related to the fact that there were that rule of evidence.
Correct.
Pretty consistently.
Correct. The statements out of court that generally come in are inconsistent statements, not consistent statements. Again, because I just think there is such a value, and I can't emphasize this enough, that a jury of 12 people who know nothing about a case come in and watch and bring their life experiences to determine if someone is guilty or not guilty. And, that's the important evidence, looking at the witness in the stand.
Thank you for that answer. On a not quite related question, I mean, we have him talking about a case in which there was a jury trial. The federal and the state constitutions both guarantee a right to trial by jury in both both criminal and civil cases. I was wondering if you could please speak to us a little bit about what you believe the role of juries to be in our court system, in our system of justice, on both the civil and the criminal side.
Well, I think the juries are the finders of facts. They determine the credibility of witnesses. They bring collectively life experiences that you can't recreate in any other fashion. I have found juries to take their obligations seriously. I know everyone, when we do our jury introduction in the courthouse, wants to know, how do I get out of jury duty? But once they've served, they realize what a valuable experience it's been. And to a person, they have always said how much they really enjoyed it because they actually got to see the judicial system at work. They got to see the efforts of the attorneys, of the marshals, of the clerks, of the judge, giving them detailed instructions on the law. And I just think it's the best system in the world. Not that we can't get better. We should always look to improve, but it's a tremendous system. And again, to have the ability to have a jury trial is just one of our most precious rights.
Well, thank you, Judge. That's been my experience as well. I appreciate your answering all of our questions, and congratulations on your nomination. Thank you, Mr. Chair.
Further questions or comments? Representative Doucette.
Thank you, Mr. Chair, and thank you, Judge, for your answers and your testimony this morning. I did have one additional follow-up question on the Turner case. You spoke to the appellate review of that case and the issues that we've been talking about today. And you may have mentioned, but I don't recall hearing, was your conduct or your prosecution in the case the subject of any complaint or proceeding at the Criminal Justice Commission or anywhere else?
No, not my conduct, my objection, but I consider that an evidentiary ruling, that I objected to the introduction of this tape. So the same thing that has been brought today, but not as to my conduct.
Correct. But so not outside of that proceeding or the case itself.
No.
Okay. Okay. I think that's important to understand for lay people listening, you know, what we're talking about today. And I think I would assume the appellate record really goes into really great depth on this question. So I do think it's been covered, and I appreciate your testimony and congratulate you again on your nomination.
Thank you.
Representative Callahan.
Thank you, Mr. Chairman, and good morning, Judge Alexander, and congratulations on your nomination to you and your family. I'm sure today is a nervous day, but your family's very proud of where you sit today. I have more of a comment on having worked for the judicial branch for almost 30 years. Inevitably, I get feedback from former colleagues, and I have to relate to the committee that feedback regarding your nomination has been glowing. I've heard stories about your performance as a prosecutor and as a judge and as appellate judge, and I'm certainly happy you're before us today. And we have such a qualified candidate sitting before us. So I wanted to just relate that to the committee and congratulate you again.
Thank you very much. Thank you for your very kind comments.
Representative O'Day.
Thank you very much, Mr. Chair, and good morning, Your Honor. Sorry I'm not there in person. Just a couple brief comments and a question, if I may. The comments, I did have a couple of judges reach out to me and speak very highly of you as a judge and your abilities to be fair and impartial and to treat everyone with dignity and respect. So that's kind of leads into my question. And as someone who has not appeared before the Supreme Court in more than a decade, my colleagues used to joke that I created appellate issues through my trial practice. But having tried about 50 cases to verdict, I've only been before the Supreme Court a couple of times. But I've kept my appellate team busy. But the question I have is, I know it's quite an intimidating realm being in front of the Supreme Court, and I know your temperament, having seen it both the trial level and appellate level. I'm certain it's not going to change much on the Supreme Court, but can you just tell us how, if at all, things may be different for you going from the appellate court to the Supreme Court?
I think it's a tremendous responsibility. I think that, again, it's incumbent upon any justice to listen to the litigants, to review the record, and to listen to the other justices. And I would do so respectfully, with deference, and again, with a focus to applying the law correctly.
Thank you, Your Honor. And congratulations. I think the judge, the governor made an excellent appointment, and good luck to you.
Thank you very much.
Further questions or comments? Further questions or comments? Seeing none. Judge Alexander, congratulations.
Thank you so much. Thank you for your time.
And good luck.
Thank you.
All right. Next will be Hope C. Seeley of Coventry to be a judge of the appellate court. If you could raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. Have a seat. Make yourself comfortable. Feel free to take the mask off if you want to, and you can give your opening statement whenever you're ready.
If you don't mind, I am going to keep my mask on only because I'm going to visit my 87-year-old mother.
Not a problem
So
at
I'm
all. Not a
Being
problem at all.
extra careful.
Totally get it.
So, but if it impedes anything, let me know, and I certainly will take it off. All right. Good morning. Good morning, Chairman Safstrom, Vice Chair Blumenthal, Ranking Member Kissel, and Ranking Member Fishbein, as well as the distinguished members of the Judiciary Committee. It's truly a privilege to be here today, and I want to express my appreciation to each member of this committee for considering my nomination to the Connecticut Appellate Court. I also wish to express my gratitude to Governor Lamont and his confidence in nominating me to the Appellate Court. I, too, am humbled as well as honored by this nomination. If I am fortunate enough to be confirmed, I will strive every day to serve the people of Connecticut to the best of my abilities in this new and challenging role. I have served on the bench since 2013, and I've been assigned to 3 judicial districts during my tenure. My first assignment was to the Wyndham Judicial District, where I sat for 4.5 years. I sat at the courthouse located in Danielson, and my primary assignment was as the criminal trial judge. I spent the next 4 years assigned to the Tolland Judicial District, where I served as the assistant administrative judge. And again, my primary assignment was as the criminal trial judge. But also during that time period, that was a time period when COVID hit. And during that time period, I also handled the daily docket in the lower court. In September of 2021, I was assigned to the Hartford Judicial District as the presiding criminal judge, as well as the assistant administrative judge for the district. I presently am the chair of the Criminal Jury Instructions Committee and a member of the Judicial Media Committee. I also served on the Judicial Education Committee for 7 years. In 2019, I was honored to be asked to sit by designation on the appellate court, which I found to be challenging and rewarding. Outside of my judicial branch activities, I teach a seminar course at UConn Law School during the fall called Law and Forensic Science, and I've done that for 3 semesters. I also involved in a nonprofit organization called Civics First, which promotes law-related education in our schools. Civics First currently runs the statewide mock trial competitions for both high schools and middle school students, as well as the competitions for debate. I've regularly served as a judge in mock trial competitions for middle schools, high schools, colleges, and law schools, both at the local and national levels. I recently joined the board of a nonprofit organization called Lawyers Concerned for Lawyers. And I'm also a member of the Oliver Ellsworth Inn of Court, which serves to promote professionalism, ethics, civility, and excellence in the practice of law. Prior to my appointment to the bench, I was in private practice in a small firm in Hartford for 24 years. I handled a broad variety of complex criminal cases at the trial and appellate levels, both in state and federal court. I'm very grateful to have had the opportunity to serve for the past 9 years as a Superior Court judge, a responsibility that I have taken very seriously. Thank you, and I'm very happy to answer any questions that the committee has for me.
Thank you. So your background, obviously, since being on the bench has been, I think, almost exclusively criminal. And it sounds like your practice was predominantly criminal before going on the bench. Obviously, moving into the appellate court, you're going to be confronted with a range of other types of cases, civil cases, family cases, juvenile cases. How do you anticipate making that jump to a wider variety of practice than you probably have been exposed to over the last few years, certainly while you've been on the bench?
All right. Well, on the bench as well, when I sat in the Wyndham Judicial District sitting in Danielson, that's what we call a block assignment. So while my assignment was as the criminal trial judge, in between trials, I would ask to sit in other disciplines. So I volunteered to sit in the housing court. This was back around 2013, 2014, 2015. So I did have that opportunity as a trial court judge, as a Superior Court judge, to hear housing matters during that time period, which was certainly a new experience for me. Having come to the bench with a primary background of criminal defense. I also did have the opportunity, both in Rockville as well as in Danielson, to occasionally sit in family court to hear restraining orders, as well as the civil court to hear civil restraining orders. But I agree, my background is primarily criminal. As a lawyer, I would divide my time period as a lawyer of that 24 years. The first 10 years of my practice, and more particularly the first 5 years when I was an associate and there were 4 partners in the firm, I was the only associate. There were 2 criminal lawyers and 2 civil lawyers. And I divided my time between all 4 of them. In fact, I often felt I was split into pieces to address the civil. So I did have some experience on both civil personal injury back in that time period. So yes, I would agree that the bulk of my experience has been criminal. How I would approach that in going up onto the appellate court if I were to be confirmed is to approach it in the way that I've always approached the law, which is to immerse myself into an area. That is something that I'm looking forward to doing, frankly, is to being in other areas. When I sat by designation back in 2019, the case that was assigned to me to write was not a criminal case. And I greatly enjoyed that. I greatly enjoyed rolling up my sleeves, wrapping my head around what the law was in that case, going back to principles of the law that I hadn't thought about in a long time, such as contributory negligence, and having to really flesh out those issues. So I would look forward to that. What I would do is certainly read the record, the trial court record, the briefs, do the research in all those areas of the law. And I recognize that there will be a learning curve, and that's one that I'm looking forward to.
Questions from the committee? Questions or comments from the committee? Seeing none, Judge Seeley, congratulations on your nomination and thanks for joining us today.
I appreciate the opportunity and thank you very much.
All right, we are next going to turn to our class of judges for nomination to the Superior Court. We will begin with Scott R. Chadwick of East Hartford. Attorney Chadwick, if you could raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. Have a seat, and whenever you're comfortable, you can go ahead with your opening statement.
Good morning, Chairman Winfield and Staffstrom, ranking members Kissel and Fishbein, and other distinguished committee members. My name is Scott Chadwick. It is an honor to appear before you this morning. I would like to begin by thanking Governor Lamont for the confidence he has shown in me by his nomination. By way of personal background, I was raised in East Hartford and attended its public schools. I made a home there with my wife, Wendy, who passed almost 3 years ago. She enthusiastically supported my aspirations, and I so wish she were here to witness my nomination in these proceedings. I continue to reside in East Hartford with our daughters, Emma and Sophie, and I'm thankful for the same support and encouragement their mother gave me. Since graduation from law school, I've maintained a private law practice with various firms focused primarily on civil litigation matters. In addition to my private practice, I have been able to serve the public in various positions. For 15 years, I served as corporation counsel to the town of East Hartford. In addition to the more traditional duties as corporation counsel, I handled the town's auto and general liability defense work, administrative appeals, assessment appeals, and other litigation matters. For 7 years, I served as a hearing officer for the Department of Motor Vehicles. One day each week, I would hear and decide a full docket of all types of administrative proceedings involving the department. More recently, I began serving as an alternate member to the State Board of Labor Relations, hearing disputes between state and municipal employers and employees. Since November of 2014, I've served as the Judge of Probate for the District of East Hartford. My service as Judge of Probate for the last 7 years has included some of the most rewarding experiences of my professional career. This service has allowed me to assist the town's citizens during some of the most difficult times in their lives. I'm grateful for the trust that so many have placed in me over the years. I believe that I possess the qualities and experience necessary to serve the citizens of Connecticut as a judge of the Superior Court. I respectfully request your approval and welcome any questions you may have. Thank you.
Thank you. Representative O'Day.
Thank you very much, Mr. Chair. And Attorney Chadwick, congratulations on your nomination.
Thank you.
Or I should say, Your Honor. I'm sorry. I apologize. Your Honor, as probate judge, you've obviously had a unique perspective than as compared to other lawyers becoming judges, having served as a probate judge. As you know, you got through judicial selection. And my typical question that I started asking after Justice McDonald was elevated or moved over to the governor's office was robitis. You've probably heard of the affliction. Assuming you haven't been afflicted with robitis and as a probate judge, how can you assure us that you wouldn't be so afflicted if you were put on the bench at the Superior Court?
Well, as I mentioned, I served as probate judge for the last 7 years. We don't wear robes, but every day I'm referred to as judge. And when I hear the term, it's a humbling experience. It's one that reminds me that I am a simple public service servant doing public service for those that I've been elected to serve.
You may have read that there's some issues with judges serving anywhere assigned at least 9 to 5. Are you willing to serve anywhere assigned and at least 9 to 5?
I am, of course.
In your private practice, the things that the judicial selection looks at, as you know, are experience, temperament, and intellect. And obviously, your intellect, you wouldn't be as a probate judge, and you would have gotten as far as you have without that. What kind of trial experience did you have in private practice? Would you say mostly criminal, or was it generally generally evenly split?
Almost exclusively civil. I've maintained a rather active civil practice for my 35 years of practice in conjunction with my civil or public service.
And did you have a certain focus in was it mostly personal injury type cases for plaintiff for defense?
I've had the good fortune to represent both sides, both plaintiffs and defendants. And primarily my focus has been more recently on the defense side, representing municipalities in various claims and assessment appeals or tax appeals involving both property owners and municipalities. So representing both sides, I believe, has afforded me a unique experience and served my clients well.
And when I'm trying to find the question about when was your last jury verdict?
I believe it was 10 years ago in Hartford for Judge Domnarski. I represented two defendants and was able to secure a defendant's verdict.
Congratulations on that, as someone who practiced mostly on the defense side. What jurist would you say was either a mentor or someone that you would model your self after?
There are two retired judges that I respect highly, Michael Riley and Antonio Robina. And there's the sitting judge in Hartford, David Sheridan, who's I would seek to aspire to be like and admire his abilities as both as a trial judge, but also as an administrative judge.
Those are excellent choices. I had the pleasure of trying, I think it was Judge Urbina's last case before he went on the bench. And so if that turns out, if those are your role models, those are outstanding jurists. So, well, congratulations. Thank you for your responses and good luck.
Thank you.
Representative Doucette.
Thank you, Mr. Chair. And thank you, Judge. Good morning. And I was going to make it a point to call you a judge because I certainly know you in that context. I've had matters before your office as East Hartford probate judge over the years. And I've found your office to be run very efficiently. I've always found you to be extremely fair, professional, and efficient in rendering decisions and the business that goes through the office of probate judge. As those of us who practice in that area know, that there's a wide range of operations throughout the different probate offices and districts, and it can depend on where you are and from judge to judge. But I think yours is, to my knowledge, one of the best run in the state. And I was just going to ask you too. I think being a probate judge would be an excellent experience to going over to the Superior Court bench. And while the matters that are handled in the probate court obviously are kind of more confined to certain areas, and you may have exposure to some broader areas when you get on the bench of the Superior Court. There are still contentious matters. There are still emotional matters. So I guess I wonder how you believe that your experience, and maybe you have some examples of contentious matters in the probate court, how those would translate over to, say, an assignment in the GA or a contentious civil matter or so forth in the Superior Court.
Thank you. I believe it starts with demeanor and temperament. And very early on in what I anticipate to be a highly contested, for example, a children's matter where there's emotion-packed issues and parties, that it's important that you set the rules and the expectations in advance. And it's important that you maintain consistency throughout so that you don't lose control of the hearing. Because after all, we want to make sure that we have a substantive hearing that's fair and impartial. And while parties may not agree with the decision, you want them leaving believing they were fully heard, the hearing was fair, so that they have faith in the system and ultimately the resolution.
Thank you for that. No, I think that's exactly right. And I think, again, that's why that experience in the probate court will lend itself well to your being on the bench. Also as a neighbor from Manchester, we've had the opportunity to know each other outside of the probate court over the years too. And I think you'll make an outstanding addition to the bench. So I'm very excited to see you here today. I know we're going to hear from some of our friends in East Hartford virtually shortly. So congratulations on your nomination, and thank you for your answers today. Thank you, Mr. Chair.
Thank you, Representative. All right, here comes the aforementioned East Hartford delegation, Representative Curry.
Thank you, Mr. Chairman. Judge Chadwick, it is a pleasure to see you. I apologize that I'm not there in person, as I am remote with meetings in the building. Congratulations on this great day. You know, East Hartford has had the privilege of leading a number of the branches, but has seemed to have been ignored when it comes to the judicial branch. And I know our last appointee is well over a decade. And I know that you coming in will help fill that gap and provide an east of the river viewpoint on matters before you. And the attorneys on this committee are going to, continue to ask you questions with regards to your work ethic and matters before you and all of that. I know you personally, first and foremost, as Scott and as a friend. And so I think what I'd like to hear from you today is what this position will mean to you personally, and how you will use those feelings in an approach for your work.
I've always had such a respect for the judiciary. I am the first member of my family to go to college, law school. I'd always wanted to be a lawyer since I think it was 7th grade, and just singularly focused on attaining that goal. Public service too has always been very important to me, and to be able to combine the two would be tremendously satisfying. And if being a Superior Court judge is half as rewarding as being a probate judge, I wouldn't be more thrilled. Couldn't be more thrilled.
I appreciate that. And, for folks who don't know Judge Chadwick, he is kind, he is decent, and is a voice and a temperament that we don't always experience, especially in this day and age, and one that I think would serve the bench well. So again, I congratulate you on this nomination and would urge my fellow committee members to support this nomination today. Thank you, Mr. Chairman.
Thank you, Representative.
Thank you, Senator Anwar.
Thank you, Mr. Chair. Judge Chadwick, congratulations on your nomination.
Thank you.
And actually, Representative Curry said many of the things I wanted to say. I'm fortunate to have interacted with you, known you, and I think your integrity, your personality, your calmness, and your entire demeanor is something that is a gift, and East Hartford and the community in the region has benefited from that gift, and it's time for the rest of the state to benefit from it. So I would just hope my colleagues would recognize what an impressive person you are and what a good individual you would be to serve as a judge. So I would just urge others to join me in supporting you, and I wanted to congratulate you for being nominated. I don't have a question, just wanted to make those comments. Thank you.
Thank you, Senator.
Thank you, Senator. Further questions or comments from the committee? Senator Kissel.
Thank you very much, Chairman Staffstrom. Your Honor, congratulations.
Thank you.
You also have my deepest sympathies. I know it's 3 years ago, but on the loss of your wife.
Thank you.
My caucus has an interest in these questions, so pretty much all the candidates will be asked these questions too. My first one, and I think I can guess at this, you are elected to be a probate judge, and I'm just wondering which party you're a member of?
Democrat.
Yeah, I pretty much guessed that, East Hartford. Being from Enfield in North Central Connecticut, East Hartford does have a reputation of a lot of tremendous Democrats, not the least Congressman Larson, who I serve with in the legislature since I've been here for 30 years, but certainly Representative Curry's mom, Melody Curry, who also went on to work in the Malloy administration and did an excellent job. So congratulations. My other question is, how long have you been on the list for potential judgeship?
I believe it's been 8 years now,
Okay.
2014.
Yeah, and again, these are generalized questions that my caucus wanted me to ask. I do believe that Governor Lamont has done an excellent job in having diverse nominees to the bench. And I believe, and I don't want to sound disparaging towards prior Governor Malloy, who I got along with very well, but there seemed to be the sentiment that he very much preferred Democratic candidates as opposed to Republicans. I think Governor Lamont is more balanced, and the whole balancing of folks has changed over the years, and it changes with each administration and their chief counsel, I would guess, as well. So absolutely, your background as a probate judge and as the municipal counsel and your trial work will behoove you very well. I wish you the very best as you move forward in your legal career. And I know you'll be a tremendous asset to the people of the state of Connecticut. And thank you for your answers. Thank you, Mr. Chair.
Thank you, Senator.
Thank you. Further questions or comments? Representative Fishbein.
Mr. Chairman, I just want, for the record, as you know, I'm recusing myself from this appointee. So my lack of questions is not based upon lack of interest. So thank you.
Duly noted. The record will reflect, and we'll excuse you during the vote, which we hope to take at some point later today. Further questions or comments? If not, Judge Chadwick, congratulations on your nomination. Thanks for being with us.
Thank you all.
You know what? I will also just note for the record, you're excused, Attorney Chadwick. I'll also note that Representative Veach will be recusing herself on this nomination as well. So just wanted to put that on the record as well for you, Representative. All right. Next up will be Victoria Chavey of West Hartford.
Good morning.
Good morning. If you may raise your right hand, do you swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. Make yourself comfortable, and when you're ready, you can give us your opening statement.
Good morning, Chairman Staffstrom, Chairman Winfield, Ranking Members Kissel and Fishbein, and other distinguished committee members. I want to start by thanking Governor Lamont for nominating me to serve as a Superior Court judge, which I view as a vital role in our system of justice and one in which I would be honored to serve. I've lived in Connecticut for the last 30 years, moving here in 1992 after law school. My husband, Mark, and I met at Dartmouth College and then went to BU Law School together, Boston University. We've raised two wonderful children who are now 21 and 24 years old. My husband stopped practicing law almost 10 years ago, and he currently teaches history at Bulkley High School in Hartford. I come from a close family. My parents, Tony and Joanna Wooden, moved to Hartford about 15 years ago to live near us, and I have one sister, Allison Vogt, who is an anesthesiologist in Rochester, New York, where she lives with her family. I began my legal career here in Hartford, clerking for Chief Justice Ellen Ash Peters at the Connecticut Supreme Court. And then I spent a second clerkship year in New Britain with Senior Judge Thomas J. Meskel on the Second Circuit. I was incredibly lucky to have the opportunity to work with these two distinguished judges, who, as you know, came to their judgeships after very different career paths, but had numerous fundamental commonalities. What stands out in particular is that they were both keenly aware of how the law, including judicial interpretations of the law, impact individual people who engage directly and indirectly with our judicial system. In 1994, after my clerkships, I began as an associate in the Hartford office of Dayberry and Howard, which later became Day Pitney after a merger. I started in the employment law department of the firm's trial section, which was very busy and presented great opportunities for new lawyers to learn and grow and to try cases. The practice at that time was led by Albert Zakarian and Felix Springer, whom I consider to be giants in Connecticut's legal landscape and whom I'm lucky to call friends even now all these years later. I became a partner at Day Pitney in 2001 and then left to join Jackson Lewis in 2010. Last year, I decided to move my practice towards serving as a neutral rather than as a trial lawyer, and I established a solo practice known as Chevet Legal Services just 7 months ago. It's been very rewarding, and I've enjoyed finding new ways to use my legal skills and experiences. I've also devoted considerable time to working with organizations that I believe make valuable contributions to our community, such as the Freedom of Information Commission, to which I was appointed as a commissioner in 2019, and the Connecticut Bar Foundation, of which I currently serve as board vice president. I also have leadership roles with the Connecticut Coalition Against Domestic Violence and with my church, the Asylum Hill Congregational Church in Hartford. And I'm also a regular volunteer with Food Share. My various experiences have given me the benefit of many mentors, colleagues, and friends from whom I've learned a great deal and who have helped me in innumerable ways in my career. I approach this nomination with humility and a commitment to serving the public and the work of justice. And again, I want to thank you for the opportunity to appear here today. I'd be happy to answer any questions that you may have.
Thank you. Representative Fishman?
Thank you, Mr. Chairman. Good morning and congratulations on your
Good morning. Thank you.
nomination. One of the interesting aspects of your service is sitting on the Freedom of Information Commission. When were you appointed in 2019?
When during the year?
Yes.
I believe it was in the fall of 2019.
Okay. Because I believe the nominee before you also was appointed at the same time. So am I to understand that if you get through this and become a judge, that you would no longer be on the Freedom of Information Commission?
Yes, that's right.
As well as the prior nominee. Have you been involved in any of the hearings? I mean, I know I've brought, which I ended up withdrawing, matters before the commission involving the governor and his lack of compliance with the Freedom of Information Commission. Have you been involved in any of those cases?
The commission has heard, the commission that I'm a commissioner of, hears contested cases that have recommended decisions from the hearing officers, the lawyers who work, generally the lawyers who work at the FOIC, and we hear the cases that haven't been withdrawn or settled. There have been cases involving requests to the governor's office that we have decided.
Okay, and just, I'm very familiar with the process. The hearing officer, not you folks, has a hearing.
Right.
Takes in evidence. The hearing officer makes a recommendation to your body as to whether or not to make a finding or dismiss or whatever. And then you perhaps have a proceeding where the litigants would come and argue to you why the recommendation should be accepted or not.
Yes.
And that's your role.
Yes, exactly.
Okay. And well, I'll do some more digging, but interesting that we have, and I haven't seen this with other nominees, that the two people that would be coming off the Freedom of Information Commission and then be reappointments. So I know openness and transparency has been a concern during this administration. So I thank you, and once again, congratulations on your nomination.
Thank you.
Representative O'Day.
Thank you very much, Mr. Chair. Good morning.
Good morning.
Congratulations on your nomination. Just a couple questions that I have been asking everybody. Seeing as you've been with a number of big firms, you probably have seen the affliction called robitis on occasion. Is that fair to say?
Yes.
And so, one of the things, I know you've gone through judicial selection, and as I've stated before, the three things that judicial selection looks at are experience, temperament, and intellect. How can you assure us that once you get on the bench, you will not be afflicted with robitis?
Thank you for the question. I live a lot to my professional practice, to my personal life, that leads with humility and treats everyone with respect and dignity. And my track record in that regard will carry through if I am confirmed as a judge. And I think it's very important for judges to be good listeners, to be humble, to seek to learn from the litigants and from research and from colleagues, and not to pretend to have all the answers, because judges don't have all the answers, and they really need to listen and seek to learn every day. And that's how I would approach the role of a Superior Court judge if confirmed.
Thank you for that answer. And I agree with you. I think the key is humility. One of the keys to being a good judge is humility. So I very much appreciate that response. And so as someone who also left a big firm, I went from a 100+ lawyer firm to a smaller firm like yourself. Without getting into any detail, can you just describe for me kind of you're going from Dayberry to Jackson Lewis, two really big firms, and then to Chavy Legal Services LLP. What was the kind of the impetus to those changes and how your practice changed?
It was a decision I made very carefully, and after a lot of thought. It was not a quick decision. I really was looking for a new challenge and a new opportunity to serve as a lawyer, which I love, but do it in a different way, and to serve as a neutral rather than an advocate and a trial lawyer was a role that really drew me. My goal in Chavy Legal Services is to serve as an arbitrator and mediator, and also to do outside investigations as an objective outside person where necessary. And it was really my desire to serve in that role rather than confine myself to the role of advocate, which I've loved, and I enjoyed my career in both of my large firms, but I really wanted to do something different and use my skills in a different way, which I think I'm suited for.
Thank you for that. And I see your practice is 100% civil. We do have a very good judges school. So if you're assigned to criminal, I assume that's something you're willing to take on?
Absolutely. In fact, before law school, I worked at the Manhattan DA's office. And then after my first year of law school, I worked in the U.S. Attorney's office in Boston. And there certainly was a time when I could foresee me pursuing a career in criminal law. Didn't end up happening that way, but I would really relish the opportunity to do that if it were presented.
And the question I've been asking everyone, in addition to the robitis, is: are you willing to work at least 9 to 5 anywhere in Connecticut, including from West Hartford, if you're assigned to Stamford, Connecticut, which is in my backyard?
Absolutely. I have worked hard my entire career, and that is not going to change.
And I see one of your cases listed. It appears as though that was down in Stamford. So you have practiced down here in Stamford commuted from down to Stamford from West Hartford, correct?
I have, and I've practiced. I've traveled to New York for work. I've handled a number of cases there as well.
Great. And under percentage of litigation the last 5 years, 60% jury, 40% non-jury. So you have had an opportunity to pick juries and litigate within the last 5 years. Any verdicts?
I have. I had my last verdict was in Hartford Superior Court. It was a jury trial, and we got an advert. I was on the defense side. We had a plaintiff's verdict, and it was an interesting case. But yes, it was. I believe it was about 3 years ago.
Okay. And as someone who went from a big firm to a small firm, the question I didn't ask the previous nominee, motions for continuance certainly consented to. I assume you'd look generally favorably on those if they're consented by both sides. The reason I ask, I actually had, when I was with this smaller firm, a continuance denied a number of years ago, even though it was consented on a courtside trial that was assigned without me picking the day. So needless to say, the client was unhappy, I was unhappy. So I guess my long-winded question to you is, coming from a big firm, would you listen to an issue that a small firm practitioner might have with respect to scheduling and having problems with that coming from a small firm?
Absolutely, yes.
Obviously, that's something that I'm interested in, making sure that judges, particularly judges that or practitioners that come from a big firm, it's much easier. I would be able to get a lot of help, but in a smaller firm, it's much harder. So, well, congratulations on your nomination, and I thank you for your responses. Thank you, Mr. Chair.
Thank you.
Senator Kissel.
Thank you very much, Mr. Chair. I just want to pronounce this correctly. Is it Chevet?
Chevet.
Chevet. Congratulations, Attorney Chevet. Just the questions that I had asked the previous candidate. My first question would be, have you run for any elected office in your career?
No, I have not.
Okay. And how long have you been on the approved list of nominees?
I believe it was 2020, so about 2 years ago, a little less than 2 years.
Okay. And outstanding background, and I know you're going to do a wonderful job, and congratulations. Thank you, Mr. Chair.
Thank you.
Further questions or comments? Seeing none, congratulations on your nomination. Thanks for being with us this morning.
Thank you very much.
All right, next up will be Thamar Esperance Smith. Good morning, ma'am. If you could stand for me and raise your right hand. Do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or in a penalty of perjury? Great, thanks. Make yourself comfortable, and whenever you're ready, feel free to give us an opening statement.
Good morning, Chairman Winfield, Chairman Staffstrom, Ranking Members Kissel and Fishbein, and esteemed members of the Judiciary Committee. My name is Tamar Esperance Smith. I thank you for this opportunity, and I am honored to appear before you today. I would like to first thank Governor Lamont, as I am both humbled and honored by his nomination and confidence in me to faithfully execute the duties of a Superior Court judge. I would also like to thank my husband, Joe, and my parents for their unwavering support. I am a mother to 3 wonderful children, and they each inspire me. By way of background, I come from humble beginnings. I'm a first-generation Haitian American. My parents immigrated to the United States in the 1970s when Haiti was still ruled by a dictator. Because they were among the first in their families to immigrate to the United States, they served as beacons of hope to other Haitians in the community. They would help all of the newly immigrated Haitians in any way that they could, and I remember providing my translation services ever since I was a child. My father is a pastor of a small Haitian church, and my mother a retired nurse. They instilled deep values in my brothers and I, which included hard work, integrity, and helping others along the way. Most importantly, they stressed that what made the United States the greatest country in the world is the rule of law and equal access to justice. They came from a country where justice was not provided to all and embraced a country that upheld the rule of law. They taught me that the best thing we could do as American citizens is to help one another. As a result of their love and guidance, I have been fortunate enough to have dedicated my career to public service. Immediately following law school, I had the opportunity to clerk for a pool of Superior Court judges, where I performed legal research on complex issues and assisted judges in drafting their legal opinions. This experience first ignited my passion to become a judge because I was able to see justice in action and the power of a perceptive judge to make a difference in contested matters. It also strengthened my ability to make conclusions based on facts presented and the law. At Greater Hartford Legal Aid, I represented individuals who could not afford an attorney in various civil matters and ultimately was assigned to the Family Law Unit, where I represented victims of domestic violence in matters including divorces, custody, child support, and immigration. Prior to my departure from legal aid, I assisted in the development of the Medical Legal Partnership, where lawyers were brought into healthcare settings to combat health inequities by providing free legal services to patients. Legal aid was a very rewarding and humbling experience, as it provided me with the opportunity to work with people who were not as privileged, going through immensely difficult situations. It required a great amount of patience and empathy. I then had the pleasure of becoming an assistant attorney general, where I now serve in the collections and child support department. In this position, I represent various government agencies in multiple forms, including Superior Court, Family Magistrate Court, and Probate Court. In addition to my career in public service, I'm a member of local and national organizations where I enjoy coordinating and participating in community service efforts. I'm also the current president-elect of the George W. Crawford Black Bar Association and serve on the statewide grievance committee's Talon panel. Additionally, I'm a James W. Cooper Fellow with the Connecticut Bar Foundation. I would like to continue my work in public service and to ensure the rule of law in a challenging and rewarding way. If I'm fortunate enough to be confirmed, I will uphold the rule of law and promote equal access to justice. I thank you for your time and I welcome any questions.
Thank you. Senator Kissel?
Thank you very much, Chairman Staffstrom. Attorney Esperance Smith, congratulations.
Thank you.
So your parents came over, I'm trying to remember, Haiti, was that like Papa Doc, Baby Doc, those guys?
Yes, it was.
They were really bad guys.
They were.
Yes. Congratulations. And I think you'll bring a lot of very varied background. Again, along the lines of the questions that some of my caucus members are intrigued by, have you ever run for any elected office?
No, I have not.
Okay. And how long have you been on the list of approved nominees?
Since 2021.
So just about a year.
Yes.
Okay, interesting. Again, congratulations and thank you very much, Mr. Chair.
Thank you.
Representative O'Day?
Thank you very much, Mr. Chair, and congratulations on your nomination.
Thank you.
I see you've been at the AG's office for a couple of years now, 3 years.
Yes, I have.
You know, one of the things I know you've probably heard me asking this question. I know going through judicial selection, which I was chair of for a period of time, you know, you look at temperament, intellect, and experience. And so my robitis question is, you know, how can you assure this committee that once appointed to the bench, you will not be afflicted with robitis?
Well, like I referenced in my opening statement, I was raised with deep values that were instilled in me. I've always treated people with respect, and I will continue to do so. A robe isn't going to change that.
Excellent. Thank you. And as far as experience, it looks like 100% civil, non-jury over the last 5 years. And certainly, we've had a lot of people come from the practice of law and become judges who don't have jury trial experience. I assume from your responses that you've never picked a jury?
No, I have not.
We do have an outstanding judges school and a mentoring program, so that in and of itself is fine. But I guess my question to you is, I assume that you've had to handle things that you've never seen before as a lawyer, correct?
Absolutely. And in my experience as a law clerk, I've had to research different areas of the law and come to conclusions based on the facts presented and the law.
And so I assume as a judge, you're not going to have a hard time going to colleagues, asking questions and researching issues as well, correct?
No, I will not.
Where did you clerk as a judicial clerkship? Where was that?
I was in the Hartford JD in Superior Court.
And so were you clerking with basically all the judges?
Yes, it was a pool of judges, and they would select clerks. It was a pool of clerks, I apologize, and the judges would select clerks to come and assist them in short calendar hearings and in trials in complex matters.
And when I was on the hiring committee in my old firm, I always looked for clerks first because they saw as much as what to do, they also saw what not to do in the practice. So I think that's a fantastic experience. Who would you say would be your judges that you would model yourself after, or maybe potentially mentors of yours?
I've had so much experience with judges, and it would be really hard to select, just one. I could say Judge Alvis, Judge Don Westbrook, all judges that exemplified extreme intellect, great demeanor, temperance, patience with individuals before them, and were able to come to fair conclusions and resolving cases.
And then you probably heard me ask the question about working at least 9 to 5 in any jurisdiction in the state. Would you be willing to accept an assignment anywhere and work at least 9 to 5?
Yes, I would be able to work 9 to 5 faithfully.
And anywhere in the state?
Anywhere in the state.
Excellent. I think that's all the questions I have. Thank you so much for your responses and congratulations on your nomination.
Thank you.
Senator Anwar.
Thank you, Mr. Chair. Attorney Aspirant Smith, congratulations on your nomination. I just wanted to say a couple of things to you. After 2010 earthquake in Haiti, I had the opportunity to be there. And while I was there, I saw the challenges that people were facing, but I saw the resilience of the people, where they lost everything that they had. And when you're taking care of those individuals, you would ask them, how is everything? And they say, God is great. And I said, well, that's just one person saying it. And after 10 people said the same thing who had lost everything that they had, including their family, the resilience, the capacity, and the connection with the higher power was just inspiring. So, and I've gone time and again over there, and it's one of the most special people in the planet. Many of my Haitian American friends call me Haitian, and I could not resist but to make a couple of comments. And I can tell you that I have yet to see anybody, Haitian American in our state, who's just not incredibly amazing individual. And I'm glad that our governor has nominated you to be on as a judge, and I look forward to supporting you. Thank you so much.
Thank you.
Thank you, Senator. Representative Porter.
Thank you, Mr. Chair, and congratulations on your nomination. I am so sorry that I am not in the room with you right now. Some great questions have been answered. You have been asked, and you've given some great answers. And the good representative asked you about judges who you'd like to model yourself after. I would be interested in you telling us, growing up, you spoke of, your upbringing. who was the person that influenced you the most and would be able to take some credit, if not a lot of credit, for where you are today?
Honestly, the person and I would have to say the people, it's split equally between my parents. They've really had a profound impact on me, watching their journey, the immense difficulties that they've had to overcome in this country and to raise their family. That is who I've modeled myself after, and I'd like to keep their integrity going and to continue to model myself after their fortitude.
Well, thank you for that response. And I can tell you, I am absolutely positively certain that they are extremely proud of you, because I am. And it gives me such great pleasure. I would like to personally thank the governor for this nomination in particular. We talk about modeling. I just need you to know that there are a lot of little girls that look like you right now, knowing that anything is possible. So continue to do what you've been doing. I wish you all the best. And I look forward to seeing your continued success and capacity as Superior Court Judge. I'm going to speak it. Thank you, Mr. Chair.
Thank you, Representative. Representative Doucette.
Thank you, Mr. Chair. And thank you, Attorney Esperance Smith. Just wanted to chime in briefly. We had a chance to meet just briefly, but I found you then and I found you today to be very impressive and excellent candidate. I'm very pleased, excited to see you up there. And I did want to offer to Representative O'Day's question, as a resident of the town of Glastonbury, I think you are very accessible to all corners of the state. Jump on Route 2, Route 3, down 91. And as one of the representatives from Glastonbury, not your representative, but close enough, I did want to add that. But no, I'm very excited to see you up there. Congratulations. And thank you very much for your answers today. Thank you. Thank you, Mr. Chair.
Thank you. Further questions or comments from the committee? Further questions or comments? If not, Attorney Esperance Smith, congratulations and good luck to you.
Thank you.
Next up will be Jeanette Figueroa Lascos of Shelton. Finally getting out of Greater Hartford for a change. If you could raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. You can have a seat, and whenever you're ready, go ahead with your opening statement.
Good morning, Chairman Winfield, Staffstrom, ranking members Kissel and Fishbein, and the esteemed members of the Judiciary Committee. I'm honored to appear before you today. My name is Janet Figueroa Lascos of Shelton, Connecticut. Thank you to Governor Lamont for the nomination to be a Superior Court judge. I was born in Bridgeport, Connecticut, and raised in Derby, Connecticut. While my parents did not have any college education, they encouraged my brother Michael and I to attend community college. Then I went on to the University of Connecticut. After graduation, I worked at Marrakech in New Haven, where I helped adults with disabilities establish and maintain independent lifestyles. This required patience, understanding, the ability to listen, and show respect. The people that I worked with also required advocacy to obtain and maintain services. I credit this experience for my decision to pursue law. With the help of our parents, family, and friends who provided support for our children, Monica and Nicholas, I attended law school while my husband, Peter Lascos, went on to earn an MBA. As a prosecutor, my Spanish language skills and eagerness brought me the opportunity to sit second chair in my first major trial in Stamford. I interviewed many witnesses who only spoke Spanish and dealt with the reluctance of many witnesses to testify. I believe that diversity at all levels of the legal system is essential to combat that reluctance and make the judicial system accessible to all. I have worked as an assistant attorney general in child protection for the past 18 years. I am in court on a near daily basis representing the Department of Children and Families in highly contested neglect cases with overlapping issues of substance abuse and mental health concerns. My coworkers, opposing counsel, court personnel, judges, and social workers are dedicated to helping families overcome obstacles while being empathetic and respectful. I'm very aware that my path here is due to the support and guidance of my coworkers, family, friends, bar associations, and I am eternally grateful. I humbly ask for your approval, and I'm happy to answer any questions.
Thank you, Attorney Figueroa Lascos. Are there any questions? Senator Kissel.
Thank you very much, Chairman Blumenthal. Attorney Figueroa Lascos, congratulations.
Thank you.
Quite a diverse background. I don't think we've had a lot of folks that started off in community college, but I have the utmost respect for folks that attend community college. And not to sound biased, but Assunta Community College up in Enfield, my neck of the woods, is an excellent institution.
It is.
And I actually think nowadays, since the first 2 years of most colleges, it's actually much more efficient to go there, get your base coursework, and then you can transfer anywhere else you want to go. Have you ever run for elected office locally?
I have not.
Okay. And how long have you been on the list of approved nominees?
9 years.
9 years. If that's the extent of my questions, I think you have tremendous credentials. Again, I would commend Governor Lamont on his nominating you. And I think your breadth of experience will bring an awful lot to the bench. And you'll be a wonderful, continue your career as public servant for the good people of the state of Connecticut. Congratulations. And thank you, Chairman Blumenthal.
Thank you.
Thank you, Senator Kissel. Representative Rabimbus, you have the floor. And ma'am, she'll be appearing virtually, just for your information.
Thank you, Mr. Vice Chairman, and good afternoon, Attorney Lascos. Congratulations on your nomination. I actually don't have any questions. I just certainly wanted to lend my voice of support. I've had the pleasure of seeing Attorney Lascos for many years and a very long time ago, actually in the courtroom, and I found her to be absolutely fair and very respectful of everyone that's come before her. So it's about time that we certainly see her nomination to excel up to the bench. So Attorney Lascos, congratulations on your nomination.
Thank you. I appreciate that.
Thank you, Mr. Chairman.
Thank you, Representative Rabimbus. Representative O'Day.
Thank you very much, Mr. Chair, and congratulations. Good afternoon and congratulations. I figure I should be consistent in asking the same questions of everybody. You probably heard me ask the Robitis question. And so just based on the comments I've heard so far, I think I know the answer, but how can you assure members of this committee that if you are elevated, that you will not be afflicted with Robitis?
I can assure you I would not. I've always been respectful to everyone I've come in contact with, and it would be against my nature to do otherwise.
Thank you. And being in Shelton, you're kind of in the center part of the state, which is a good thing. So my next question should be easy to answer, but are you willing to work at least 9 to 5 anywhere in the state that you're assigned?
Yes, I am. As an assistant attorney general, I have practiced in different parts of the state, including Waterford, Torrington, Bridgeport, and Waterbury. And as I indicated earlier, I've also traveled to Stamford back when I was a prosecutor, which was quite a commute, but well worth the commute for the experience.
Thank you for that response. And I see over the last 5 years, you've got 100% of your experience in the non-jury area. Presumably you've picked jurors before when you were working as the state's attorney's office?
Only on one occasion. It was for a jury trial in Stamford. And that was the only time I sat second chair. I was not the main counsel in that case. But other than that, no, I have not been able to pick juries.
Well, we have a very good judges school and mentoring program. And so I guess one of my questions that I think I've asked everybody is, are there any particular judges you would consider mentors or that you would model yourself after?
Throughout my career, I've had the opportunity to see so many judges that I would model myself after. I would not choose just one, but I would focus on the demeanor and to be fair, listen to both sides and be respectful, and to make a decision fairly. And those are the attributes that I would want to model.
And as you having come from the AG's office and state's attorney's office, continuances probably haven't been much of a problem for you. But as someone who has gone from big firm to a small firm, hopefully you be considerate of a small-time practitioner who may not have the resources or the schedule flexibility that some of the bigger firms would have. And so if you had a consented to motion for continuance, hopefully you'd look at that favorably.
I would always look at the circumstances for the request as fairly as possible. Yes.
Excellent. And those are all the questions that I had. Thank you so much for your responses and congratulations on your nomination.
Thank you.
Thank you, Representative O'Day. Are there any further questions or comments from the committee? Seeing none, I'll just ask you one question. You've had a very varied and diverse experience in your practice as an attorney, and I was just curious if you could name a lesson or two that you learned over that time that you think will be helpful if you have the opportunity to serve on the bench.
I think it's always important. The biggest lesson is to try to listen to what the other side is arguing and try to look at it fairly. I often, in my own practice, try to look at the opponent's point of view. And I think it's very important in trying to reach a consensus because if you take into consideration where they're coming from, it may change your position a little bit in order to find something that's fair for both sides.
Well, thank you for all your answers today, Attorney Figueroa Lascos, and congratulations on your nomination. Best of luck.
You.
Next up will be Attorney Josephine S. Graff of Glastonbury. If you would raise your right hand for me, whenever you're ready. Do you swear or affirm, as the case may be, that the information you will provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Thank you very much, and you may begin your opening statement when ready.
Thank you. Good afternoon, Chairman Staffstrom, Winfield, ranking members Kissel and Fishbein, and esteemed members of the Judiciary Committee. It is an honor to appear before you. I want to thank Governor Lamont for the confidence he has shown in me by his nomination. By way of background, I grew up in Wethersfield, where my parents raised me and my 3 younger brothers. My parents taught us to treat everyone with kindness and respect, lessons that have helped me become the person that I am today. I live in Glastonbury with my husband, Kevin. We have been married for 14 years and have 3 children, Bobby, age 12, Tony, age 10, and Charlotte, age 7. Kevin and I are extremely proud of our children, and while they keep us on our toes, they also keep us humble and grounded. I graduated from the College of Holy Cross in 1998 and the University of Connecticut School of Law in 2001. My first job out of law school was as a judicial research clerk for the Superior Court. In that role, I researched legal issues and drafted decisions for Superior Court judges. I then went on to work in private practice for 6 years. During that time, I handled a variety of cases, and my practice was largely focused on civil defense work. I was hired in 2008 to work in the Attorney General's office in the Employment Department, where I have been ever since. I defend the state of Connecticut in employment cases in both state and federal court. My clients range from maintenance workers to commissioners and other agency heads and everyone in between. I handle cases from the day that the complaint is filed through its resolution, whether that be through dismissal, a settlement, or a trial. I have handled appeals at the state's appellate court and the Second Circuit. I have worked tirelessly, including nights and weekends, to ensure the best possible outcome for each case that I have handled. 20 years of courtroom experience has taught me to be open-minded and to treat people with respect, no matter what position or title they hold. I believe that everyone deserves to be heard, And my most positive experiences with judges have been when the judges have taken the time to talk to each side and treat each side equally. I routinely represent people who have never been in court, and I am mindful that this can be a daunting and intimidating experience. It is important that a judge create an atmosphere of comfort and fairness for all sides and all participants. I have dedicated the last 14 years to public service and look forward to continuing my public service as a Superior Court judge. It is an incredible honor to be appointed a judge, but with this honor comes great responsibility. I pledge to this committee that if confirmed, I will do my absolute best to create a courtroom of openness and fairness for all. Thank you for your consideration, and I am happy to answer any questions.
Thank you, Attorney Graff. Questions and comments from the committee. Representative Doucette.
Thank you, Mr. Vice Chair. And thank you, Josephine, Attorney Graff, for being here today. We go back quite a ways, probably, I guess, to 2000 or so. We went to law school together. And I'm so excited. I'm so proud to see my law school colleagues come through here. We had Eric Lohr a couple of weeks ago, who was one of the stars when we were there. And now we have you, and you were certainly a star in my experience when we were there as well. I found you back then to have the demeanor, seriousness, studiousness, era of professionalism, something that not all of us, it may surprise some of my colleagues to know that it had at the time, but I think you exude that professionalism, and I think it will lend itself well to you being on the bench. I did, I guess, have one question, of sort of a variation on ones that Representative O'Day and others have asked. I guess I'm curious who inspires you or who has inspired you, either a jurist, another lawyer, or just someone else in your life that influences your work that you do today.
Sure. I have been inspired by Judge Noble, who I've been most recently in front of. I thought that the way that he handled the case that I had in front of him was very good, and that he treated everybody with fairness and respect. He had a calm demeanor. He was able to talk to both sides outside of the courtroom in a pretrial situation so that the trial ran smoothly. And that's something that I would aspire to do if I were on the bench.
Thank you. And also, not to steal Rep. O'Day's thunder again, but another Glastonbury resident. Sorry, Chairman Staffstrom stepped out. We have quite a few from up in my neck of the woods. So I think you would certainly, and I know you to be someone very hardworking. That would be someone who certainly would put in beyond the 9 to 5 and go anywhere to fulfill your obligations as a Superior Court judge. Am I right?
Yes, thank you.
Okay. Well, thank you very much. Again, very happy to see you up there. Thank you, Mr. Vice Chair.
Thank you.
Thank you, Representative Doucette. And it does seem that Glastonbury is doing very well today, so we'll have to look into that. Senator Kissel, followed by Representative Callahan.
Thank you very much, Chairman Blumenthal, and appreciate Representative Doucette sort of preempting one of Representative O'Day's questions about the 9 to 5. Attorney Graff, congratulations. Have you ever run for elected office?
No,
Okay. And how long have you been on the list?
about a year.
About a year. Okay. So we have like the more traditional 8 to 9, and then a group of folks that have only been on the list for about a year. I mean, a year is a long time, but still. And there's just people that reach out to me that have been on that list a real long time. Well, congratulations. Certainly your experience in the courtroom will be extremely helpful as you move on to your next career step. And I know that you'll be a tremendous public servant once again in a different capacity for the people of the state of Connecticut. And again, I would commend Governor Lamont for his wisdom and his selections that are nominees before us today. Thank you very much, Chairman Blumenthal.
Thank you.
Thank you, Senator Kissel. Representative Callahan.
Thank you, Representative Blumenthal. Congratulations, Attorney Graff. I'm sure your family's very proud on this very exciting day for you to be on your nomination. Regarding a question Representative O'Day has asked many of the people who've come before us today. I recall in working in judicial for many years, I used to, as a chief probation officer, would go to whenever a new judge came in, I'd provide my card and offer any help I could be in any cases they need to attend to. And I do recall one judge that came to Danbury years ago, threw it back at me and said, "Why would I ever need to talk to you?" And I think that's a symptom of what Representative O'Day referred to as robitis. And I wondered how you feel, and would you have any danger of being afflicted by robitis?
Thank you for the question. In the last 14 years, I've been lucky enough to serve the public, and I've been humbled enough to serve as an assistant attorney general. I would continue to be humbled in being on the bench, and I would continue to treat everybody with fairness and respect if I were on the bench, just as I have in my practice.
Thank you. And a question on, in listening to your background, it appears most of your work has been in civil. Is that correct?
That's correct.
How would you feel about being placed in a criminal court or family court?
I would have no problem with that.
All right. Well, congratulations, and thank you, and have a good rest of your day.
Thank you.
Thank you, Representative Callahan. Are there further questions or comments from the committee? Further questions or comments? Representative O'Day.
Thank you very much, and congratulations. In looking at your experience, I see that you probably spent a lot of time at Sylvester and Daly and Gordon Muir picking juries. Is that fair to say?
Yes.
Yeah. You know, the questions on serving anywhere in the state and at least 9 to 5 and the robitis issue have been taken care of. And in taking a look at your experience, it looks as though your last 5 years has been mostly non-jury, but you still have done some jury trial work.
That's correct. The cases that I handle in employment, I've done some most recent federal jury trials, but in the state court, it's been bench trials.
And having done both federal and state jury selection, I like to ask this question: which one do you prefer as a litigant?
I actually, as a litigant, I prefer the federal jury system because I think it's a quicker system.
Okay, as a litigator, which one do you prefer?
I mean, sorry, as a litigator, yes.
Well, I will say that that's where, don't take this, it's not going to affect my vote with you, but as a trial lawyer, I love the state court system because you get to know the jurors much better. The one bad result that I had was a federal system because it was just a literally an hour and a half, 2 hour process, and you get your jury, whereas state court, it's a week. So we'll respectfully agree to disagree on that, but no problem there. Well, thank you very much for your responses and your being here, and good luck and congratulations.
Thank you.
Thank you, Representative O'Day. Are there further questions or comments from the committee? Further questions or comments? Seeing none, thank you very much for being with us today, Attorney Graff, and congratulations on your nomination.
Thank you.
Next up is Attorney Stephen D. Jacobs of New Haven. You would raise your right hand when you're ready. Do you swear or affirm, as the case may be, that the information you'll provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Thank you very much, and you may begin your opening statement when ready.
Thank you, Chairman Blumenthal. Good morning, Chairman Winfield, Chairman Staffstrom, Ranking Members Kissel and Fishbein, and other distinguished committee members. I am Steve Jacobs, and I am honored to appear before you and most grateful to Governor Lamont for having given me this opportunity. I am truly humbled. I am a third-generation American and a third-generation lawyer, the son of Dick Jacobs, an indefatigable pugilist who at nearly 92 is still relentlessly pursuing justice for his clients, and the grandson of Israel Jacobs, a bold and brash criminal defense lawyer, and Albert Miller, a more mild-mannered generalist. I'm the eldest of 4 boys born to our mother, Carrie Jacobs, all within a span of 5 years. My blessings are almost too numerous to count. I am married to the bright and beautiful Rosemary Reinecker, without whom I would not be sitting here today, Rosie having encouraged me to apply for a judgeship. I have 3 children, 2 daughters, Haley and Marnie, both of whom are graduates of the University of Connecticut, and Haley, the recipient of a master's in social work degree from Southern Connecticut State University, and a son, Teddy, aged 9.5, who's in the 4th grade at Hamden Hall Country Day School. I've had the privilege of practicing law with my father for 36.5 years, and with my cousins, Bruce and Allison Jacobs, for the past 11 years. I began practicing law in 1985, a year which is numerically distant, but which to me feels like yesterday. The practice of law has a way of causing time to accelerate. Since pledging to engage in the practice of law, quote unquote, without lucre or malice, I have represented hundreds of injured people in the state of Connecticut, in the state courts, the federal courts, and before the Connecticut Workers' Compensation Commission. I have tried dozens of cases to verdict. I've handled cases ranging in complexity from the most mundane rear ender to the most complex product liability and medical malpractice case. I have practiced both in the state and federal criminal courts. From 1987 until 2013, I was a member of the United States Criminal Justice Act panel for the state of Connecticut, taking appointments to represent indigent criminal defendants. I have argued numerous appeals in the Connecticut Appellate and Supreme Courts, the United States Court of Appeals for the Second Circuit, and the Compensation Review Board of the Connecticut Workers' Compensation Commission. I've handled and tried cases of wrongful discharge and employment discrimination, and prosecuted charges of employment discrimination in the Connecticut Commission on Human Rights and Opportunities and the United States Equal Employment Opportunity Commission. I've represented individuals in matters before the state of Connecticut Department of Labor. I have represented individuals in matters involving consumer rights and breach of contract. I have handled a smattering of landlord-tenant disputes, both on the landlord and on the tenant side. My father always told us, quote unquote, we're no better than anybody else. And so I've always kept in mind that my law degree did not make me any better than anyone else, and that I should accord every human being the same amount of dignity and respect, regardless of how they look, where they've come from, or what they believe. This, I believe, is the essence of good judging, making decisions without being judgmental, approaching each situation with neutrality toward the parties and their representatives, humility and fidelity to the law. If I'm given the honor of being confirmed as a Superior Court judge, I will work to ensure that all litigants, whether the winner or the loser of a case before me, leave the courtroom with an understanding of the decision and a belief that the judge was fair, scrupulously neutral, well-versed in the law, patient, and thoughtful. I hope that you will grant me the opportunity to serve the citizens of the state of Connecticut as a member of the bench of the Connecticut Superior Court. Thank you, and I welcome your questions.
Thank you, Attorney Jacobs. Senator Kissel.
Thank you very much. And even though you're the vice chair, I'm still calling you chairman, since you're running the show for the time being. So you come from New Haven, which I was joking with Senator Looney when we were voting on the 40-odd new nominees from the first batch, saying that it appeared to me that New Haven was like the epicenter for the judicial branch, despite what Chairman Staffstrom said about Greater Hartford. and the nominees today. And I would say, first of all, congratulations, Attorney Jacobs.
Thank you.
But you were talking wistfully about starting to practice law in 1985 when I'm sitting here thinking, I started to practice law in 1984. So yes, when we enjoy what we do, time does seem to pass by very quickly. But I think that's just sort of life. I think the older you get, the more rapidly it flows. But that's just me.
Well, they say that wisdom is wasted on the young. So,
or youth is wasted on the
or
young, right?
youth is wasted on the young.
Right. Have you ever run for elected office?
I have not.
Okay. And how long have you been on the approved list of nominees?
About a year.
About a year. And your wife deserves the credit for urging you to apply through the process?
She does. It is something that I've toyed with over the years, but she was the one who really pushed me.
Well, you certainly come from a storied family. The fact that your dad's out there and you refer to him as a pugilist, that he's out there slugging away, I'm guessing he's still practicing law in some way, shape, or form.
He is.
Yeah, and he's in his 90s?
He'll be 92 on May 5th.
Yeah, that's just amazing. But, you know, you hear these tales. I don't know how true they are. But, you know, a lot of people, if they're so immersed in their careers that as soon as they retire, it actually doesn't work well with their own health, especially if they don't have a plan for something to keep them engaged. And I think just being engaged in life in some way, whether you're employed or it's some other thing that you like to do, charitable work. I just commend my friend and colleague, Senator Saud Anwar, who talked about going down to Haiti after earthquakes in his role as a physician. And obviously he was volunteering in some way, shape, or form, or assisting with a charitable group trying to aid those people. So the human body's made to stay busy and the mind as well. I don't have any criticisms. I mean, you've actually, what an incredible career. You've been on both sides of so many different things. I can't imagine that won't be of great benefit to you on the bench. And I just think that you'll be a tremendous public servant for the people of the state of Connecticut. And again, I commend Governor Lamont on the variety of individuals that have come before us. Thank you very much, Chairman Blumenthal.
Thank you.
Thank you, Senator Kissel. Next up is Representative Dillon, followed by Representative Callahan.
Good afternoon. I want to congratulate you on your well-deserved nomination to the court and thank the governor for his judgment. And I really can't say enough about you and your family, but I particularly want to thank you for the work that you did for Jewish Family Services for many years. They provide critical services to a part of my district, actually, which doesn't have access very often to the food pantry because of transportation and so forth. And I don't know if you've been honored for that, and I should know if you were, but I want to congratulate you on your career. I don't know what it's like to be an underperformer in your family. It would have to be difficult, but I'm excited to see you here, and I want to thank you for your service to the state.
Thank you, Representative Dillon.
Thank you, Representative Dillon. Next up is Representative Callahan, followed by Representative Fishbein.
Thank you, Mr. Chair, and Attorney Jacobs, congratulations for being here today. And you and your family must be very proud of this day. When it comes to the questions that you've heard Representative O'Day ask to other candidates, other nominees, I should say, when you've heard the term robitis and the affliction that sometimes afflicts some of our judges, can we be assured that you will not be afflicted by this?
I would tell you that 63 and a half years of life as a humble individual has inoculated me against the disease.
That's a great answer. And also, would you be willing to serve in the capacity as a judge on whether it be family criminal and anywhere in the state, and certainly from at least 9 to 5?
Absolutely.
Well, thank you for your answers, and thank you, Mr. Chair. Congratulations.
Thank you.
Thank you, Representative Callahan. Next up is Representative Fishbein, followed by Representative O'Day.
Thank you, Mr. Chairman. Good afternoon, Attorney Jacobs.
Good afternoon.
Just for the record, and I don't know if you recall, approximately 10 years ago, I did have you, I referred some collection matters to your office. I just want that to be on the record. It doesn't in any way, shape, or form affect my vote here today. I know in the community, and you did a good job. I don't.
Thank you.
No, thank you. You know, I just want to be open about that. And, you know, I know your reputation in the community is stellar, and I congratulate you on your nominations. Thank you.
Thank you very much.
Thank you, Representative Fishbein. Representative O'Day, you have the floor.
Thank you very much, Mr. Chair or Vice Chair, and Attorney Jacobs. Congratulations on your nomination. I have had cases with your office. You and your office have always been very professional, and I have no reason to believe that anything would change. And I do believe, for those that are watching, humility, I think, is a key component. And your answer was outstanding. That's the first time I recall hearing someone said, my 63 years of life experience have inoculated me to robitis. That's outstanding. So, and as someone who has come from a smaller firm, you probably have needed a continuance or two that was most likely consented to. I assume that you will be reasonable in evaluating requests for continuances as a member of or as a judge.
I would want to be as accommodating to people in that situation as judges have been accommodating to me.
Thank you. And as someone who's obviously tried a lot of cases, picked a lot of juries, who would you say that some of the jurists that you had the most respect for and would like to model yourself after, if any?
So a couple come to mind. I'll start with Judge Ellen Burns and Judge Mike Camp and Judge Matt Frechette. But Ellen Burns, the late Ellen Burns of the United States District Court, was a wonderful judge. She was thoughtful. She was deliberative. She was considerate of everybody in the courtroom. She gave everybody ample time to present their cases. She was humble. She was, if there was something that concerned her, whenever there was something that concerned her, she would call the lawyers to the sidebar, straighten things out. And I'm saying this in spite of the fact that not all of her decisions were favorable to me, some very disappointing, in fact. But she was great, and I'd say the same thing about Matt Frechette and Mike Camp. I mean, these are judges who have been patient and thoughtful and treated both sides equally, had tremendous equanimity, never gave an inkling that they were inclined toward one side or the other, and they were especially respectful of the jurors. So these are the people that I look to as role models.
Excellent. Thank you for that response. That is quite a list. What system do you prefer as a litigator, the federal or state system of jury selection?
Hands down, the state system. We are lucky in Connecticut to have individual voir dire as something that's protected by our Constitution. The opportunity to spend as much as 30 to 45 minutes with each person who comes up on the panel really can't be beat. It doesn't assure you of a perfect jury selection, but it tells you a hell of a lot more than what you discover through the federal jury selection process.
I agree with you completely on that. Thank you very much. And again, congratulations on your nomination and good luck to you, sir.
Thank you very much.
Thank you, Representative Day. Further questions or comments from the committee? Further questions or comments? Seeing none. Thank you, Attorney Jacobs, for your answers, and congratulations on your nomination.
Thank you very much.
Next, we will hear from Alina Marquez Reynolds of Fairfield. If you might raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. You can have a seat, and whenever you're ready.
Good afternoon, esteemed members of the Judiciary Committee. I want to begin by thanking Governor Lamont for his nomination and for placing his trust and confidence in me. I also want to take a moment to thank his General Counsel, Nora Danahy, for her guidance, and to everyone at the Governor's office who assisted and supported me during this process. I have had the good fortune of having extraordinary role models and mentors throughout my career, and I am so grateful for all of their support as well. I would not be here today at this place on this day without the love and support of my family and my friends. I am a first-generation college graduate and the first person in my family to attend law school. In the early 1960s, my parents and my brothers fled Cuba to Colombia, where I was born. We came to the United States because my parents, especially my dad, who only made it as far as the 8th grade in school, knew that it would be here in the United States where we would have the best opportunity to build a new life. My parents instilled in me and my brothers the importance of hard work and of community service, and these values continue to guide me to this day. And finally, a special thanks to my husband and best friend, Steve, who's here with me today, and to our 2 boys, David and Jack. I couldn't be more proud to be their mom. I have had the privilege of spending almost my entire career in public service, first as an assistant district attorney in Brooklyn, New York, and then as an assistant United States attorney here in Connecticut for nearly 25 years, where I worked hand in hand with federal, state, and local law enforcement to investigate and prosecute primarily violent crimes. While the role of a prosecutor is obviously different than that of a judge, the goal is the same, to seek justice. And that was my focus as a prosecutor in each and every case. And now, if I am so fortunate to be approved by this committee and by the General Assembly, it would be my greatest honor and my greatest privilege to return to public service as a judge of the Superior Court, a position in which it would be my duty to ensure fairness in the process, to ensure that everyone who appears before me leaves the courtroom feeling that they were fully informed and understood the process, that they were listened to, and that no matter what the outcome, they were treated fairly and with respect. I would strive to treat everyone with respect, not just the litigants, but everyone who makes a courthouse run, the security officers, the court reporters, the jurors, the clerk's office personnel, everyone. I will work hard to build trust in the system, guided by those basic values instilled in me by my parents, to give back and to serve. Thank you for this opportunity and for your consideration.
Representative Fishman.
Thank you, Mr. Chairman. I just want to start, what is your legal name?
Alina Marquez Reynolds. When I was born Alina de Pilar Marquez, and then when I got married, I took my husband's name, which is Reynolds. And
Okay.
so I use Marquez as my middle name.
So when I reviewed the backup of the court filings, it was Alina P. Reynolds.
Correct. Pilar was my middle name.
Okay. And then I've seen references to Alina Mercado Reynolds.
It's Marquez.
No, I
Mar-
understand. And Marquez and Mercado are spelled differently. So any references to Mercado Reynolds is just wrong?
Yeah, that's incorrect. That's
Okay.
not my name.
That's, I got it. Okay, thank you. And you are presently, what do you do now presently?
I work at a nonprofit in New Canaan called the Grace Farms Foundation. I've been there a little over 2 years. And I serve in 2 functions there. I work with the Justice Initiative to combat human trafficking and gender-based violence. We do a lot of training and outreach in that area as part of the Justice Initiative. And then I also serve as a general counsel, where I manage outside counsel and handle the legal affairs for the foundation.
Okay, according to the backup, you started doing that in October of 2019. Is that accurate?
That is correct. I left the U.S. Attorney's Office, and so at the end of October of 2019, I joined the foundation.
Okay, so then looking at the backup, and this particular line is very, very small in the backup, just so that you know. It says, "At general counsel at a nonprofit, I oversee all legal matters and manage outside counsel and handle internal investigations, compliance, and in-house training," I think is the last word.
Yeah, and I apologize. I had some difficulty with the form. Every time I tried to make it bigger, it just erased it. So I apologize that it came out that way in the form. But yes, at the foundation, again, I wear 2 hats. I'm the general counsel, and I also work with the Justice Initiative.
And when did you first go through judicial review or judicial selection?
I went this year in January. I applied and I was interviewed by the commission in January and went on the list in January of this year.
Okay. And when were you first licensed to practice law in Connecticut?
I was licensed to practice in the district court. Obviously, that's federal court. But I became licensed admitted as in-house, as house counsel in 2021, and just recently admitted as a full member of the bar in this year.
And when you say this year, was that that was after you went before judicial selection?
That is correct. And what happened was this opportunity presented itself and the timing was right for myself and for my family. So I forged ahead with the judicial selection application, with the interviews, and with that whole process. And it was really an inadvertent oversight on my part that I had to become a fully admitted member of the Connecticut bar and not just admitted as house counsel. And so when that came to my attention, I did everything in my power to get all of the paperwork before the bar examining committee. And I was fortunate that they were able to expedite the review. And I am now a fully admitted member of the Connecticut bar as well.
Okay, so at the time of your application in January of 2022, you were not a fully admitted member of the Connecticut bar.
That is correct. I was admitted as house counsel, which is my current role at the foundation.
Okay, can you explain to me what's the difference?
Well, the way I understand it, there are 2 ways to waive into the Connecticut bar. You can waive in as house counsel, which is what I did for the role I'm in. But to be fully licensed, and so in that capacity, I can represent the foundation, which is what I was doing. But to be fully licensed, you have to waive in as a full member of the Connecticut bar.
So in order to practice as house counsel, you have to be licensed as house counsel, is that?
Correct.
Okay. So explain to me this then. In October of 2019, you were not licensed as house counsel in the state of Connecticut.
That's correct. Well, that's when I first joined, but I was, in the process of getting that done, and I got admitted in 2021 as house counsel.
But at the time of you obtaining that employment and representing to that entity, as well as perhaps the public, that you were a general counsel to that entity, you were not licensed to do that, correct?
That's correct. But if I could explain what I did, and I'm the only lawyer at the foundation, largely my role was to manage outside counsel who represented the foundation in court proceedings, before the Planning and Zoning Commission, et cetera. So they are the ones who appear in court and actually represent the foundation. I was more in the capacity of an advisor. And then when I wanted to do more than that, I did do the paperwork and get waived in as in-house
Okay, so
counsel.
we have a state statute 5188, which has to do with being licensed to practice and making certain representations. Are you aware of that statute?
Not specifically, no, but I mean, I would understand that if you're going to practice in state court, you'd have to be fully admitted in state court.
Well, it's more than that. So it would be a Class C misdemeanor to hold oneself out to the public as being entitled to practice law. So in October of 2019, you obtained employment as general counsel for a Connecticut firm, but you are not licensed to do so. Is that what I'm hearing?
That is correct, but I was not appearing in court or representing.
That's not what the statute says. I'll read to you all of the things that are prohibited. Practice law or appear as an attorney for another in any court of record in the state. Make it a business to practice law or appear as attorney at law for another in any court. Make it a business to solicit employment for an attorney at law. Hold himself out to the public as being entitled to practice law. Assume to be an attorney at law. Assume, use, or advertise the title of lawyer, attorney, counselor at law, counselor at law, so on and so forth, in such a matter as to convey the impression that he is a legal practitioner of the law. That's where I'm having a little difficulty in, October of 2019, assuming the position, general counsel, and I could see if, I'm waiting, I've applied, stuff like that, but it's not until like 2 years later that a license is obtained to do this job in the state. Am I getting something wrong there?
No, I mean, I think it was my understanding, and again, I wore two hats. I was part of the Justice Initiative and did a lot of training, outreach, and policy work, advocacy work. And as the general counsel, my function was to manage outside counsel. It was much more of an administrative function. And again, this is an inadvertent oversight on my part, when I realized I wanted to perhaps be more involved in some of that litigation that the foundation was involved in, then I did waive in as in-house counsel. And so it may be strange, we wear a lot of hats at the foundation, but it was outside counsel who represented the foundation and appeared before the courts, the administrative proceedings, et cetera, throughout that time period. And I was much more of an administrator, just managing them.
And what was the representation to judicial selection when you went before them in January of 2022?
That I was admitted as in-house counsel in the Connecticut bar, and that I'm fully admitted in New York bar and admitted since 1995 in the District Court of Connecticut.
So
it
then,
asked where you were admitted, and I listed where I'm admitted.
okay. So then if that was sufficient for that body, then why then thereafter apply to become a full member?
Because it came to my attention that it isn't sufficient as far as becoming a Superior Court judge. And as soon as that came to my attention, then I completed the paperwork to waive in as a full member of the Connecticut bar.
Now, you mentioned when this opportunity presented itself. How did this opportunity present itself?
Well, over the years, I've always considered going to be a Superior Court judge. It just, the timing wasn't right for my family. And then I saw that, there was an opportunity to apply and be considered. And so I took it upon myself to fill out the paperwork and be considered, because the timing was right at that point for myself and my family.
Okay.
So it's something I've always considered. And over the holiday, it really came to over the holidays. My husband and I were talking about future steps. He's also a lawyer, and it has to work right at home. And we made the decision jointly that I should apply and seize the moment, of this opportunity at this time.
When you say over the holidays, the Thanksgiving holiday or the Christmas holiday?
It was the Christmas holidays.
Okay, so am I to understand that you submitted an application early in January and judicial selection expedited your application? Because that's not, in my experience, that's not how it works. You don't get on that quickly.
I don't know. I know I submitted the application with all the supporting documentation. And then I was called and told I would have an interview at the end of January, which is when I interviewed before the entire commission.
Okay, thank you. Thank you, Mr. Chairman.
Representative Callahan.
Thank you, Mr. Chairman. Congratulations on your nomination. Appreciate you appearing before us. Do you have any criminal or family experience in Connecticut courts?
In Connecticut courts, no. My experience has been in federal court in Connecticut.
Okay. And when it comes to being the court, the state could assign you to any court in the state and any under either discipline, a civil, family, or criminal, or would you have any problem with that?
I would have no problem with any assignment.
And also, I did hear what your opening statement. It seems kind of futile to ask this question, but you heard us bring up the term robitis. Would we have any danger of you being afflicted with this?
No, it's just not in my nature. To me, it's not about the title. It's about the job and working hard and treating everyone with respect. And not just myself, but making sure that anyone I'm working with, anyone on my team, also treats everyone with respect. Again, there would be no concern in that regard for me.
Well, I appreciate the answer because as a judge, and I will mention this to some of the other people that the nominees that will come before us today, you do set the tone as the staff in the court does look up to you. And I have experienced judges from the bench, not that you would ever do this, and I wouldn't suggest you would do this, but I did experience judges berating staff, and that word of that spreads like wildfire through all the disciplines in the courthouse. And hearing you talk about how important staff is refreshing to me. So I thank you for your answers, and good luck with as this process moves forward.
Thank you very much.
Representative Baudet.
Thank you, Mr. Chair, and thank you, Attorney Reynolds, for your testimony here. And as someone who lives in New Canaan and is very familiar with your employer and the wonderful work that you do and Grace Church does, I thank you for all your years of work there. Just real quick, going back on your experience, you probably heard me ask the question when you go through judicial selection, they look at your intellect, experience, and temperament. And obviously intellect, you're more than qualified. And as someone who went to Providence the same time you were at Georgetown, we may have overlapped at times at basketball games and the like, but I see that you tried a couple cases in 2018 and 19 with some colleagues at the U.S. Attorney's Office. Who did you try those cases with?
I tried one of those cases with Assistant United States Attorney Joe Viscarondo, and that was before Judge Bryant. And then my final trial as an AUSA was with Gordon Hall before Judge Arterton. And it was interesting because my first trial as an AUSA was with AUSA Gordon Hall before Judge Arterton. So it came full circle. But those were the colleagues that I tried those cases with.
Excellent. You may have heard me ask Attorney Jacobs the question. Have you ever picked I gather from your experience, you haven't had an opportunity to pick a jury in state court, seeing as you practice the U.S. Attorney's Office in New York. Is that fair to say?
That's correct. I haven't picked I haven't done trials in state court. I have attended state court as a potential juror and been through the jury selection process from the point of view of a potential juror, but I haven't myself picked a jury in state court.
With the understanding that you don't know, you haven't appeared before any state court judges or many, certainly not recently. Is there a particular judge or that you would say you would try to model yourself after, or who you admire as a jurist?
Yes, again, and it would be more as to their qualities, and I would echo what Attorney Jacobs just said. Judge Burns, I had the good fortune of appearing before Judge Ellen Burns in federal court on a number of occasions. And she comes to mind, as well as Magistrate Judge Fitzsimmons, who I appeared before almost on a daily basis. I sat in the Bridgeport office of the U.S. Attorney's Office. And these were judges who, again, treated everyone with respect, really set the tone, as we talked about, had great temperament. And it wasn't just when they gavelled in, but when they when people were watching, but that at all times they treated everyone in chambers, people walking through the hallway, all staff with respect, and really set the tone from the top. And so that's who I would strive to emulate.
Thank you very much for that. And obviously I've appeared before them as well. And those are two excellent choices. Now, I do have a number of friends that are at the U.S. Attorney's Office, and we would joke, that they, how do you like it? And one of my friends, who I won't name, said, well, it's great because we work for the wealthiest client in the world, the U.S. government. And so no stone would go unturned if need be. And so it kind of leads into my question. You haven't had the opportunity to practice in a small firm. I've done both a large firm and a small firm. I've never practiced for the U.S. or any state government. But my long-winded question is, if you had a consented to continuance request, presumably working for the U.S. government, the resources you have, you probably didn't have to file too many continuances, but would you be willing to take into account the scheduling and other conflicts that may exist for a small firm, small-time practitioner?
Yes, I mean, I think I would look at the circumstances of the request and keep an open mind. And I wouldn't judge a small firm or a big firm. I would judge it on the circumstances of the particular request, and certainly would be open to, particularly if it's on consent, to agreeing with the request.
And just to briefly, you're admitted, are you still admitted to practice in federal court?
Yes.
And so when was the, in being admitted, when was it that you were actually admitted into state court?
Just recently, just as a full member of the Connecticut Bar, just last week.
Okay. Well, I just want to say that for those that don't know on this committee, the Grace Farms Foundation is one of, if not the, in my humble opinion, most outstanding nonprofits that does so much for so many. I know the people that began it, and I know you worked very hard there. And so I thank you for your work there. And Grace Farms Foundation is just an outstanding organization. I guess, let me ask just one question. If anybody's concerned about your lack of state court experience, if you will, particularly with juries and whatnot, how would you put those concerns at ease at this point?
Well, I think I would say, first of all, even though I practiced in federal court, the nature of the cases that I worked on in my near 25 years there were, as I mentioned before, violent crime cases. I did a lot of domestic violence cases. And so there was a lot of crossover between federal court and state court. While I didn't try cases in state court, I was often over there many times in Judge Devlin's courtroom when he was sitting in Bridgeport negotiating resolutions both in the state court and in the federal court, because there was so much crossover between the defendants in the cases I tried and the defendants in state court. So I'm familiar in state court with state court in that regard. I also started my career as an assistant district attorney, not in this state, but in New York. And so I'm familiar with the state court practice, the reactive nature, et cetera. And finally, I should say that even though I just recently was admitted as a full member of the Connecticut bar, my bar association activities have always been with the Connecticut Bar Association. And you don't have to be a full member of the Connecticut bar to be a member of the Connecticut Bar Association, but I certainly worked very hard over the years with putting together programs for the Connecticut Legal Conference every year. I sit on the Human Trafficking Committee. I co-chair the Forced Labor Subcommittee of the CBA's Human Trafficking Committee. And so I've always worked very closely with my colleagues in state court who do both federal and state court. So I just wanted to make that clear as well.
And presumably you wouldn't have a problem reaching out to colleagues if you had any questions or concerns after judges school about any assignment whatsoever?
No, none whatsoever.
All right, thank you very much for your responses, and thank you, Mr. Chair.
Representative Dubitzky.
Thank you, Mr. Chair, and thank you, Attorney Reynolds, for coming in. A couple of things. I just wanted to follow up on what Attorney Fishbein was discussing. Now, I'm looking, you started with the Grace Farms Foundation as their general counsel in 2019, right?
That's correct. And again, it was two hats. I'm also the deputy director of the Justice Initiative, and a large part of my day is that job.
Got it. And you were at the time not admitted to the Connecticut bar in any capacity, right?
That's correct.
Okay, and you served as general counsel until 2021 before you acquired authorized house counsel status?
That's correct. It was in 2021 that process completed, and I waived in as in-house counsel. Yes.
Okay, so for 2 years you operated as in-house counsel without being admitted to the Connecticut bar as in-house counsel.
That is correct, but I do want to explain that I did not represent them. In other words, I reviewed what our outside counsel would file, for example, in a proceeding before the Planning and Zoning Commission, et cetera. I did not sign those pleadings. They signed on behalf of the foundation.
But your title was general counsel.
That's correct.
Okay, and when was it that you became admitted to the Connecticut bar fully?
The full admission was just last week.
What day?
Thursday of last week.
Thursday of last week, you were sworn in as a Connecticut attorney?
That is correct.
Okay. All right. And how, under what circumstances were you sworn in?
As soon as, because this was an expedited review, as soon as I received the letter from the Bar Examining Committee saying that they were recommending me for admission, I was able to contact a judge that I know, and I was sworn in by her, and then I filed the paperwork. I think that's what you're asking. That was how it happened.
Okay, and where did that take place?
That took place here in Hartford.
Okay, so it was a Hartford judge?
Yes.
Okay, and that was on Thursday?
Yes.
Okay, thank you. Thank you, Mr. Chairman.
Senator Kissel.
Thank you very much. Attorney Marquez Reynolds, congratulations.
Thank you.
Just my 2 cents before I ask you my question. It's my understanding through personal experience that corporations typically may hire outside counsel or have their own legal departments or some combination thereof. Many corporations, and it could be a business entity organized as an LLC or something else, may have business practices in a variety of states, and it's my understanding that there's no requirement that the general counsel of that business entity would have to be a member of the bar in every single state where that entity, where that business entity does business. And if they were going to transact some sort of legal business, such as defend or bring an action, either someone within their own legal department would be a member of the bar and sign off on the papers, even though the general counsel might oversee that, or they would hire an outside firm that has bar membership in that jurisdiction as well. So while it's unusual, and I don't think in my 30 years as a state senator that I've ever seen anybody become a member of the bar 1 week before being nominated as, or not even, I'm not even sure how the timing was between becoming a member of the bar and when the governor announced your nomination. But while interesting, I don't see it as, from my perspective, and I only speak for myself, as an impediment whatsoever. Have you ever run for any kind of elected office?
I have not, no.
Okay, so I won't bother asking a political affiliation or anything like that. I just think that your background is quite unusual. Do you consider yourself more Cuban or Colombian or some sort of like combination, or more I'm American and that's what I relate to, or how does that whole identity flow?
I consider myself Cuban American. My parents, my brothers, my entire family is Cuban. I was born in Colombia as a result of my family leaving Cuba. We lived there several years before we came to the United States, but so I have my godmother and other friends in Colombia, my identity is more as a Cuban American.
And not that this is a qualification, but just my own curiosity, if nothing else. Do you speak Spanish?
I do. I'm fluent in Spanish.
You are fluent?
Yes, I am.
Okay. And for what it's worth, I just think that in certain circumstances and certain jurisdictions within the state of Connecticut, that can prove extremely helpful. I know that I just know that in the practice it's helpful. And certainly I think as a member of the judicial branch, it could be extremely helpful as well. But again, I'll leave that to Judge Carroll and how they work out having new judges get sent out throughout the state of Connecticut. I've always sort of like, I can't guarantee it, but it always seems to me that your first assignment's a GA and it's never really close by. It's a haul. Probably it's a little bit of baptism of fire. And if we can send you from one corner of the state to the other, and you're willing to do that while you're bright-eyed and bushy-tailed and so excited about becoming a new judge, then everything else will just be like easy as cake. So I think you bring a lot of diversity, and clearly Representative O'Day's speaking on behalf of the organization. I think anything that would motivate you to leave the job that you had with the U.S. Attorney's Office would have to be something really good to leap to. And I don't see any of that as difficult to understand. And so congratulations once again. And I know you'll be a wonderful public servant for the good people of the state of Connecticut. Thank you very much, Mr. Chair.
Thank you.
Thank you, Senator. Further questions or comments from the committee? Further questions or comments? Seeing none. Congratulations so much on your nomination, and good luck.
Thank you so much.
Next up would be Brian Perleski. Attorney Perleski, if you could raise your right hand. Do you swear or affirm, as the case may be, that the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury? I do. Great. Make yourself comfortable, and whenever you're ready.
Good morning, Chairman Winfield, Chairman Statstrom, Ranking Members Kissel and Fishbein, and other distinguished committee members. My name is Brian Perleski. I'd like to thank Governor Lamont for nominating me to serve as a judge of the Superior Court, and his General Counsel, Nora Danahy, and her Executive Aide, Janice Denell, for their assistance in the process. If approved by this committee and the General Assembly, I'll work every day to justify the confidence that's been placed in me. By way of personal background, I was born in New Britain and grew up in Bristol. I was blessed to grow up in a home that emphasized education and hard work. My mother was a homemaker, and my father worked 3 jobs through my childhood to support our family. He remains the hardest working man I've ever known. My parents valued education. Neither of my parents was given the opportunity to graduate from high school, but they raised 3 children, all of whom have advanced or professional degrees. I've tried to follow my father's example, and I've worked since my first job picking tobacco at the age of 14. I've worked as a dishwasher, a laborer, a short order cook, anything I could do to pay my bills while attending the University of Connecticut as an undergraduate, and later the University of Connecticut School of Law. My legal career began in 1991 as an associate attorney at the law firm of Pepe & Hazard, where I concentrated on commercial and construction litigation. I was appointed a deputy assistant state's attorney in 1993, and I've served as a prosecutor since that time. In 2011, I had the honor of being appointed to my current position, state's attorney for the Judicial District of New Britain. I've also been fortunate to have experience representing individuals with legal issues. While serving as a judge advocate in the Army Reserve, my initial assignment was providing legal aid services to service members, and I subsequently was assigned to a trial defense services billet, essentially the Army equivalent of the Public Defender's Office. I'd like to close by saying that I've been blessed over the past 30 years to have worked with an amazing group of lawyers, judges, and support staff, too many to mention them all by name. I've tried to learn from all of them, and it is with great humility that I appear here before you today. It's my hope that you'll allow me to continue to serve the people of our state as a judge of the Superior Court. I welcome any questions you may have. Thank you.
Thank you, Senator Kissel.
Thank you very much, Chairman Staffstrom. Attorney Perleski, congratulations. Thank you for your service to our nation in the military. You're one of the first nominees in a long time that share with me that our first jobs were at 14 picking tobacco, as is the storied past history of the state of Connecticut. There's just not enough of those farms still out there, and I don't think they're hiring 14-year-olds anymore, but I'm sure you would agree with me that you pretty much judge every job in your life after that. And as much as it was a tough job, guess what? I loved it because I didn't have to go begging for money for albums and stuff like that from my mom and dad. And it felt good to actually go out there and work hard. And I'll never forget it. And it certainly didn't harm your careers as well. As I am wont to do, have you ever run for elected office?
I have. In 2009, I ran for the Board of Finance in Avon.
And what party?
Democrat.
And were you successful?
I was not.
Oh, sorry. But just my colleagues like to know. Thanks for throwing your hat in the ring, though. There's no downside to that. And how long have you been on the list of qualified candidates that can be considered by the governor?
Since 2010.
Wow, so 12 years.
About 12 years, yes.
About 12 years. Well, congratulations. I think your wealth of experience. And, when you talked about your dad holding down 3 jobs, just looking at someone working so hard to put a roof over his family's head and food on the table, and the fact that, you know, your family instilled in you the same work ethic and respect for other human beings. To me, you're going to bring all of that to the bench. And so when there's a small or a practitioner from a smaller firm or a solo practitioner, and they're just trying to, you know, represent their clients, and they may be caught between having to be in Manchester and Rockville and Hartford all at the same time, you'll understand what that's all about on a very visceral human level. So congratulations, and I know you'll be an outstanding jurist for the good people of the state of Connecticut. And thank you so much, Chairman Staffstrom.
Thank you. Representative Fishman.
Mr. Chairman, good afternoon, Attorney Burleski.
Afternoon.
You've been the chief state's attorney at New Britain. Is that your current role?
I'm the state's attorney for the New Britain Judicial District. Yes, sir.
And how long have you been there doing that?
A little over 10 years. I was appointed effective October 1st, 2011.
Okay. I clerked there about 25 years ago in that courthouse, and I was in civil, and I got bored. And I said, send me down to criminal. And I can tell you, I was down there for 1 week. And it happened to be the week, my first day was a case where a woman choked her child to death. And I was, you know, I couldn't deal with that. The next day was jury selection in the Camacho case, which you may recall, that was a quadruple murder case. The first day of jury selection was actually, it was September 11, 2001. It was 9/11 day. So that was my only week in criminal in New Britain, and I went right back up to civil. So thank you for, I just couldn't deal with it. Thank you for being here. I will say that you have been a voice. You've been somebody who's been approachable on various issues, and I think we've come to have a decent working relationship since I've been up here, and I really appreciate your insight, your ideas, your knowledge of the system, not being one-sided, but just looking at it on an objective basis, and you've given me a lot of ideas up here too. So I very much congratulate you on your nomination here today.
Thank you very much.
Representative O'Day.
Thank you, Mr. Chair, and good afternoon, Attorney Burleski. Congratulations on your nomination.
Thank you.
I'm not sure if you remember this, but you and I rode the elevator for 3 years in our first jobs. You at Pepe and me at Halloran. And I've heard nothing but good things since on your work as an attorney for the state. And I want to thank you as well for your service to our country. You probably remember hearing my questions about robitis, and having heard your opening remarks and making reference to humility and being a fellow dishwasher at some point in time in your life, I assume robitis will not be an affliction of which you will end up having. What would you say to my question? How can you assure us that you will not be afflicted with robitis?
What I would indicate to your representative is I'm the same guy today that I was when I was picking tobacco in Simsbury 40 some odd years ago, the same guy when I was washing dishes, the same guy when I was working a line, cooking eggs. It is something I recognize. If you become a judge, you know, people are going to call you your honor, and they're going to do that because of the office that you hold. It's not you. Your job as a judge is to go in every day with humility and earn that. And I can assure you that's what I would attempt to do. And I would attempt to do that every single day.
Thank you for that response. And you probably also heard me ask the question, are you willing to serve anywhere far for Connecticut? at least 9 to 5 every day?
I certainly am.
Are there any judges that you consider role models if you were to go on?
So I've had the occasion to work almost every day for the past 28 years in our courts, and we have a great group of judges. And I've worked with some great judges. I've worked with Judge Frank Dadabo, who takes so much care and gives so much attention to every case that he tries. I've worked with Judge Mike Sheldon, who has an unparalleled work ethic. I've done charge conferences with Judge Sheldon at 11:30 at night, and a work ethic combined with an intellect that is second to none. Our current presiding judge, Judge Maureen Keegan. One of the things that's really important about being a judge is the ability to listen. Listening is the most important part of communication. And when people come into court, oftentimes they're going to leave court not getting what they hope to get from the experience. But Judge Keegan makes sure that nobody leaves that courtroom thinking that they weren't listened to. So I would want to emulate and take the very best characteristics of all those judges. And I don't mean to leave anybody out, because I really have worked with some great judges over the years.
Thank you for that. And then finally, you probably heard some of my questioning about continuances. You and I came from, Pepe and Hazard and Halloran are bigger firms. I'm now with a smaller firm. And so if you were a judge and a consented to motion for continuance came across your desk, I assume you wouldn't handle that as if the person, or let me ask it this way. How would you handle consent to motions for continuance as a judge?
So I recognize, and having done criminal work in state courts for a long time, mostly sole practitioners, individuals in small firms, and as Senator Kissel pointed out, I know that those are folks who almost every day have multiple courts that they have to be in. So I understand that those are people who need to be given some consideration and some latitude, because one person can't be in two places at once.
Thank you very much for that response. And again, thank you for all your responses. Congratulations on your nomination, and good luck going forward. And thank you, Mr. Chair.
Thank you, Representative O'Day. And I think certainly your theme for today, don't deny your continuance requests, is coming through loud and clear. Representative Pavlik D'Amato.
Thank you, Mr. Chair, and I agree with that. Mr. Perleski, I want to thank you for your testimony, and I was just wondering if you could go into a little further detail your trial experience.
Sure, I have tried approximately 60 matters to verdict in state courts, to juries. Most of those have been major felonies. The bulk of my professional experience as a prosecutor has been in Part A. So of those 60, I would say probably 50 of those were major felonies, including about a dozen murder cases.
And if you could just say again, did you ever work for a small firm, or did you start off right away doing as a prosecutor or any other area of law, whether it's clerking or prior to your current position?
So my first job out of law school was at Pepe and Hazard, which was a larger law firm here in Hartford. I worked primarily in commercial and construction litigation. I left as a third-year associate and joined the Division of Criminal Justice. I started as a prosecutor in GA-17 in Bristol. I was in Bristol for a little over 5 years before I went to Part A in New Britain. I was in Part A from 1998 until 2011. And then in 2011, I was appointed to my current position.
And so with the firm that you were at, did you have any litigation experience in civil matters? What did you do for them exactly?
Oh, I'm sorry. I did. I tried, so I did a great deal of civil litigation. In terms of trial work, I did try one civil case in state court, and I also tried a federal civil case, but I tried that as a second chair.
Okay. Well, I have to say I have the same sentiments as my colleagues, that I've only heard good things. And of course, I know you have had many years experience at the Bristol court, and everybody has great things to say about you. So I do appreciate everything that you've contributed. And I know talking with us over the years about different legislation. So thank you for that. And I am looking forward to this vote, and you definitely have my support. So thank you very much.
Thank you.
Representative Dubitsky.
Thank you, Mr. Chairman, and thank you for coming in. I didn't really have any questions for you, but I did want to make a quick comment. One of the things that I always appreciate in a judge is being able to sort of understand and commiserate to some extent with the litigants, and in criminal court with the defendants. And it seems to me like most of them have, or many of them at least, have led lives that many of the attorneys and judges have not. They've worked different jobs, they've had different life experiences. And it just seems to me that the work experience that you've had from an early age perhaps gives you a better understanding of many of the people who would be before a judge than perhaps somebody who went directly from high school to college to law school to a clerkship and then to the bench. And I think that we as a state will be very well served by having more jurists that have lived more, have more experience similar to some of the people who will be before them. And I just wanted to make that mention. Thank you, Mr. Chairman.
Thank you, Representative. Further questions or comments from the committee? Further questions or comments? If not, Attorney Pawlowski, I just want to add, as a few of my colleagues mentioned too, certainly we appreciate the resource that you have been to this committee over the last many years on a number of legislative issues, not even necessarily advocating one way or another, but being someone to use as a sounding board. I found it extremely interesting that you submitted as your writing sample your report in the Gedrin matter, which, as I know you know, and I think many members of the committee know, really in many respects was the impetus for the creation of the Inspector General in our state, and the need for that position to be created and to have subpoena power, because I think you fairly boldly in that writing sample pointed out not just the roadblocks that were put up by the local police department in doing that investigation, but your inability to get around those by not having the necessary tools. I, for one, thought it was a courageous report, and certainly commend you not just for writing it at the time, but for then presenting it back to us as your writing sample here today. So I have no doubt that you'll make an exceptional jurist.
If I can just, if I may, one of the things in connection with that investigation was I sat down a number of times with Mr. Gendring's family, and they understood the conclusions of the report. And what I indicated to them was that I would like to see some good come from this. And what I hope is that with the work that you did in the legislature and the work that our current Inspector General is doing, that we are seeing some good come from that. And what I will tell you is that Mr. Gendring's family was incredibly grateful for that.
Well, thank you. Seeing no further questions, best of luck and congratulations.
Thank you.
Next up will be Charles Stango. Attorney Stango, if you could raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or on a penalty of perjury? I do. And you have no idea how long I've waited to have you under oath. No, I'm just just joking. Have a seat and give us your opening statement.
Good morning, Chairman Winfield, Chairman Staffstrom, ranking members Kissel and Fishbein, and other distinguished members of this committee. My name is Charles Stango, and I am honored and humbled to appear before you today. I would like to thank Governor Lamont for nominating me to serve the people of our state as a Superior Court judge. It is truly the professional honor of a lifetime, and if approved by this committee and the General Assembly, I will work tirelessly to justify the confidence that has been placed in me. I am a 52-year-old son of Waterbury. My sister and I were raised by our loving parents who stressed the importance of hard work, education, and humility. I attended Waterbury Public Schools, graduating from Kennedy High School in '88, College of the Holy Cross in '92, and UConn Law School in '95. Soon after law school, my wife Melissa and I were married, and over the last 26 years, we have journeyed through life together, raising our two daughters, Kathleen, age 23, and Lauren, age 21. My first 3 years as an attorney were spent with the Waterbury law firm of Duffy and Fasano. While there, I represented individuals accused of crimes and acquired a profound respect for defense attorneys who work so diligently to achieve the best results for their clients. In April of '98, I began my career with the Division of Criminal Justice as a Deputy Assistant State's Attorney. I was assigned to Bridgeport's busy GA2 courthouse, where I spent 9 years before transferring to the Judicial District of Ansonia Milford's Part A office in 2007. Then in 2014, I was promoted to my current position, Supervisory Assistant State's Attorney for Milford's GA22. During my 24 years with the Division of Criminal Justice, I've tried cases to verdict, negotiated pleas, interacted with pro se defendants, spent hours with victims of crime, and worked with state and federal law enforcement on cases from the investigatory stage through disposition. As a leader in my community, I have never shied away from an opportunity to serve my neighbors for the greater good in both my parish and my community. The best judges I have appeared before make everyone around them feel respected, valued, and at ease, knowing that in a courtroom, everyone plays a valuable part in the process. They understand that issues that seem routine to them are anything but routine for those victimized by crime, charged with a crime, or those faced with a dissolution of marriage or a potentially daunting civil liability. These judges make certain that everyone who leaves their courtroom knows that their voice has been heard. If I am given the opportunity to serve as a judge of the Superior Court, I pledge to be that kind of judge, using the lessons of my upbringing, my legal and life experiences, and my overall desire to add simplicity and accessibility to a complex system. I will strive to do my absolute best to serve the people of our state. Thank you for your time today, and I would welcome any questions that you may have.
Thank you, Attorney Stango. Questions from the committee? Senator Kissel.
Congratulations, Attorney Stango.
Thank you, Senator.
Questions that I've been asking everybody else. First of all, have you ever run for elected office?
Yes, I was a town committee member in Waterbury and a town chairman in Waterbury. That's a direct primary election. And then I ran for Board of Aldermen in Waterbury 2003 and 2005.
In your party affiliation?
Republican.
Okay. And how long have you been on the approved list?
About a year.
Okay. Thank you very much and congratulations. And I think sort of interesting, 3 years on the defense side and then on the prosecutorial side. I have heard from some of my colleagues that there seems to be not only this sort of certain geographical nuclei to the nominees, but several states attorneys and prosecutorial candidates as well. And I don't think there's anything wrong with that one way or another. And actually, anecdotally, I've heard that, and actually, I'll ask you this question, that based on your experience, that quite often when a state's attorney or someone in the prosecutorial, either state or federal, get nominated to the bench, they almost bend over backwards to be more defense leaning to show balance. And I don't know if you ever in your travels have seen anything like that, or is that just not true?
I mean, I've heard things to that effect, but I think that the best judges I've been in front of, regardless of what they did before they became judges, are impartial and dispassionate arbiters. So that's what I will try to do.
Great, I appreciate that. That's very reassuring. And again, congratulations. Thank you very much, Chairman Staffstrom.
Representative Baudet.
Thank you, Mr. Chair. Just congratulations, Council, on your nomination. Just a couple quick questions. I know the committee's bored of hearing me ask them, but the robitis question, in listening to your opening remarks, I think I know the answer, but how can you assure us that you will not be afflicted with robitis upon elevation or appointment to the court, the judge?
Thank you, Representative. When I received that call, that I was going to be nominated to the Superior Court bench, I called my parents. My 78-year-old father was unbelievably surprised and excited. And then he kind of caught himself and said, this doesn't remove you from having to put our air conditioner in May and take it out in October, Your Honor. And I said, I know, Dad. I know. And that's indicative of how I was raised and how I would be as a judge. The robe does not give you any superpowers of wisdom. It gives you a responsibility to make the court accessible to all who come before it. And I won't forget that.
And are you willing to work at least 9 to 5 anywhere assigned in the state of Connecticut, even if it's not Waterbury?
Yes, I would anxiously handle any assignment I was given.
And I see that you did have some private practice experience, smaller general practice. The question I've been asking everybody about continuances, particularly consented to continuances. As you, I don't know if you heard, but there was a judge who I will not name that denied a continuance that I had that was on consent in a court trial, and it was particularly problematic for me. But I guess my question is, working for the state's attorney's office, you've got not unlimited resources like the federal government, but certainly a lot more resources than a solo practitioner or small firm practitioner. How would you handle consented to continuances?
I spent the first 3 years of my career as a sole associate in a 3-partner law firm, and there were days when I had to be multiple places at the same time. I think that has stuck with me. Certainly, in the post-pandemic world, I have usually handled continuance requests from counsel by just opening the file and saying, "What date would you like?" I'm very cognizant of the fact that especially private counsel have to be able to earn a living, and sometimes may have an opportunity to make a fee or something of that nature at a different location on the day the case is down. And if it's possible, I certainly try to accommodate counsel in continuance requests.
Thank you very much for those responses, and very good luck to you on your nomination process. And thank you, Mr. Chair.
Further questions or comments from the committee? Representative Fishbein.
Thank you, Mr. Chairman. Congratulations on your nomination. I just want to continue on with the continuance issue. I had a motion for continuance that I put in for last Friday when we were supposed to have this meeting, and that was denied. Understand, because I know you're in the criminal realm, but in the post-pandemic, we have remote and we have in-person, and we don't have calendars. Basically, we're getting stuff shoved on our calendars. Like the 13th, I have a remote and an in-person in the same courthouse, and I don't know how I'm going to handle both. Please be cognizant of what they're doing to us. So,
yes, sir.
Thank you, Mr. Chairman.
Representative Callahan.
Thank you, Mr. Chair. Just a brief comment. Congratulations, sir, on your nomination. I will say, as I mentioned to a couple of the other nominees, how important your position is to the court. Everyone in that courthouse looks up to you and follows your example. And I do remember as a young member of when I began working for judicial, how intimidating it was to step into a judge's chambers. So just be cognizant of that, and how your demeanor affects everybody else in the court. And I will tell you, it's good to have a crusader in front of us. I believe my little brother was the quarterback the years you were there. So congratulations and good luck on the rest of the process.
Thank you.
Further questions or comments for Attorney Stango? If not, I've got about an hour and a half, so I'll settle in now. Chuck, good to see you here. It's just it is sort of ironic that just alphabetically you come below Brian Perleski, and I know the two of you have been before this committee a number of times, and although we haven't always agreed on every legislative initiative that has come before this committee, you've always been a consummate gentleman and professional to deal with, and I have no doubt that you have the intellect, the temperament, and the ability to grant members continuances that is necessary to serve on the Superior Court bench. So with that, congratulations.
Thank you, Representative Stastrom.
Next up will be Cecile Thomas of Coventry. Attorney Thomas, if you might raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. Make yourself comfortable, and you can give us your opening statement when you're ready.
Good afternoon, Chairman Stafstrom, Chairman Winfield, ranking members Kissel and Fishbein, and esteemed members of the Judiciary Committee. My name is Cecil Joseph Thomas, and it is an honor for me to appear before you today. I'm grateful to Governor Ned Lamont for his nomination, and to General Counsel Nora Danahy and her team for their guidance and support, and to all of you for your consideration. I'm deeply humbled to be considered for this position of significant trust and confidence, and will do my utmost to serve the people of Connecticut with humility and dedication if I am confirmed. I've been a legal aid lawyer serving low-income individuals living in the greater Hartford region for my entire legal career. After an initial 18-month period of training in our benefits, employment, housing, and family units, I've served primarily as a housing attorney for the last 16 years. I've had the opportunity to represent thousands of individuals over the course of my career, and have had a variety of experiences in our state courts, complex and administrative appeals dockets, before various administrative agencies, state and federal class actions, and in appellate matters. I've been incredibly blessed by the mentorship and sponsorship of my colleagues, who have been a source of constant friendship, guidance, and support. I've been privileged also to hold various positions of leadership and trust within the Connecticut legal community, as president of the Connecticut Bar Association, past president of the South Asian Bar Association of Connecticut, and as past president of the University of Connecticut Law School Alumni Association. I've sought in each of these and other positions of trust to model my personal commitment to servant leadership. Throughout my career, I've also been privileged to have the support of many mentors and champions in these roles who have opened doors for me and helped me in my journey to this moment before all of you. I'm the son of immigrants, Joseph and Leela Thomas, who came to this country with relatively little but are the hardest working people that I know. Their primary gifts to me were not wealth or material things, but a set of values that they modeled constantly. Our faith, the importance of family and community, humility, integrity, a strong work ethic, and a deep and abiding call to service. I've sought to remain faithful to those values at all times and to honor the sacrifices that were made to provide me with the opportunities that I've had in life. I'm grateful also to my wife, Sindhu Thomas, and to our 3 sons, Isaiah, Elijah, and Joshua, for their constant love and support. Our primary hope as parents is that we will leave to our children those same values that have sustained and supported us through the happiest and most difficult of times. In my work as a legal aid lawyer, I've witnessed the transformative power of the rule of law and the impact of meaningful justice on the lives of my clients. So much of that rests in a feeling of being heard and respected, and in the assurance of a fair and just process. If confirmed, I will do my best to serve the people of Connecticut in this new role and to always uphold the public trust and confidence placed in me. Thank you again for your time and consideration, and I welcome any questions that you may have for me.
Thank you. Senator Kissel.
Thank you very much, Chairman Staffstrom. Attorney Thomas, congratulations.
Thank you.
First of all, you said that you're active in the Southeast Asian bar and that your parents were immigrants. I'm just wondering what country?
So my parents immigrated in the late 1970s from India, and so I identify as Indian American or South Asian.
Okay, great. I just wanted to know. And have you ever run for elective office?
I have not.
Okay. And how long have you been on the list of qualified candidates?
Since 2018.
2018, great. Well, congratulations. I definitely think legal aid it's a difficult job, and not because the pay is not great, because, hey, I think as elected members of the legislature, we're in the race to the bottom as far as salaries go. Not that I'm complaining, but being a judge, some people come from different income levels, and I just know that working with the underprivileged and those in need in the legal system, from my perspective, and just as this, and I know that folks from legal aid have come before the legislature over the years looking for assistance. So whatever the workload was, you've probably seen a lot. And especially, I would guess, recently during the pandemic, a lot of difficult situations, although the moratorium on evictions probably was helpful, yet there's all sorts of other things that impact people's lives. And so I think you're going to bring an interesting perspective to the bench, and I really congratulate you and your family, and commend Governor Lamont on, again, nominating great candidates that'll be wonderful public servants for the good people of the state of Connecticut. Thank you, Chairman Staffstrom.
Thank you, Senator Kissel.
Representative Fishman.
Thank you, Mr. Chairman. Congratulations, sir, on your nomination.
Thank you, Representative Fishbein.
Oh, you're quite welcome. Legal aid, it appears to me, over the last 20 years has changed. When I first started practicing, there appeared to be a lot of divorces that were start to finish, that were individuals being represented through legal aid. I haven't seen that lately over the last 10 years. Has there been a shift, or is it demographics?
So I have not practiced in our family unit since 2007, I believe. So we aren't completely siloed, but my primary familiarity is with my own experience as a family attorney during that period of time. And during that period of time, which may be what you speak to, most of the cases that I handled were from start to finish in terms of divorces. There have been various fluctuations in staffing. Our offices were hit fairly significantly by the 2008 financial crisis, which created a significant funding cut or crisis across the board. So that may have contributed in the nature of involvement. The other, I think, contributing factor may have been a focus on domestic violence temporary restraining orders, which is both a forthcoming initiative given the work of this group, which may speak to the availability for other types of family matters.
And your doings with legal aid have been more focused on the housing aspects, the evictions and that kind of stuff?
That's correct, yes.
Any other areas in the last, since 2007, you haven't been doing family. So is it fair to say that you've been doing eviction defense for the past 13 or so years?
So the majority of the time that I've spent is about 16 years in the housing unit, but as part of that, I've also been involved in federal litigation that we did on the Food Stamp Act. I've been involved in a variety of other matters related to housing as well, including, for example, issues around utility regulation. And so housing has a fairly significant coverage. A lot of the work has been eviction defense, but it also branches into other areas related to housing on behalf of our clients.
And what was legal aid's interest, or what was the case involving the food stamps that you were involved with?
So this was litigation that was brought over the state of Connecticut's processing of food stamps. And so the Food Stamp Act provides for 30-day timeliness processing for food stamp applications, or in cases that are particularly expedited, 15 days because of the emergent nature of the situation affecting the individual. At the time that we brought that litigation, Connecticut was unfortunately relatively low in timeliness processing. And so that litigation was intended to improve upon the timely processing of food stamps so that individuals would have the ability to put food on the table of their families. And so over the course of that litigation, Connecticut has now moved to one of the best in the country in terms of processing of food stamps in a timely, food stamp applications in a timely fashion.
So it's news. I had always thought that, the legal aid units around the state represented individuals for their particularized legal venue. But I'm hearing today that it goes further than that.
Our work is often very client informed. And so if we tend to see an issue that is affecting a large group of individuals, I alluded in my opening statement to some of the class action work that I've done, where a class action or other advocacy efforts seems an appropriate mechanism to address the concerns of our clients. We've taken those where there's a colorable cause of action or where that's the most impactful way to advance the concerns of our clients.
Okay, understood. And once again, I thank you and congratulations on your nomination.
Thank you, Representative Fishbein.
Rep. Doucette.
Thank you, Mr. Chair, and thank you, Attorney Thomas. I think we've had at least one case together I can remember over the years in housing court, and I think we went at it a little bit on that one, but you were a zealous advocate for your client, and I think it ultimately worked to a good resolution for both parties. But I am curious, while I have you, for a question on housing courts. And I saw from your resume that you were heavily involved with the right to counsel movement, if you will, that culminated in the legislation that we passed last year, I believe. So I get my question is, I don't recall what the implementation date on that was, but if it has been implemented, which I think it has, how is it going? I see, if not, you did some research, it looks like, in some other states that have similar programs. So I guess the experience in those jurisdictions. And then I guess, and this is the real question in my mind, being primarily a landlord's attorney. I'm primarily a transactional attorney, but I have occasion to represent mostly landlords. What would you say to my landlord clients who believe that right to counsel is something that further slants our housing courts towards favorability to the tenants?
So in terms of implementation date, eviction right to counsel, I believe we began implementation of that program in January of this year. And it has been phased in by zip code with an emphasis on the highest evicting zip codes, or the zip codes with the highest numbers of evictions across the state. And so that is how the phase in is going. Looking at other jurisdictions and other countries, phase in of a program of that magnitude has taken some time. That will certainly be the case here, as we've seen evictions reach really significant levels, pre-pandemic levels here in the state. To your point about the way the system works, the way I've always seen it is that, based upon our experience and otherwise, that the system, our system of justice, is an adversarial one. And in my experience over the years that I've done this, I've had fantastic relationships with opposing counsel, such as yourself and others that I've dealt with. I pride myself on those relationships. To me, the system works when you have equal access to justice, which is a fundamental premise of the rule of law, and that any system that has overwhelming representation rates on one side while another party with less power is not represented is not how our system was designed. And so I've always seen eviction right to counsel not as skewing it, but simply as ensuring our equal access to justice and the promise of equal access to justice that is foundational to our country.
Yeah, thank you for the answer, and I do think that's right. I supported the concept, but again, I note a little tongue in cheek that some of my clients, past clients, would be of the opinion that that adds further weight to the consideration of the tenants. But in my experience as a practitioner too, as you alluded to, having the other side represented, and I think this is probably goes in any context, is helpful to ultimately getting the matter resolved expeditiously and in a manner that hopefully is something that's pays consideration to both sides. So I appreciate that, and I think your experience, being concentrated in housing, I think is valuable, because I think you, frankly, are probably one of the experts in the state, and given your experience outside of court as well, and in the other capacities that you alluded to in the realm of housing, I think it's an impressive body of work. So appreciate your answers. Congratulations to your nomination. Thank you, Mr. Chair.
Thank you, Representative Doucette.
Representative Callahan.
Thank you, Mr. Chair. Attorney Thomas, congratulations to you and your family on your nomination.
Thank you.
You're welcome. You heard Representative O'Day and myself ask this question a few times today. If your nomination goes through and is approved, you can be assigned to any discipline or any location in the state. Would you have any issue with that?
None at all.
Thank you. And can we be assured that you would work at least 9 to 5?
Yes.
Thank you. And also, you did hear the reference to the term robitis several times today. Can you assure this committee that you will not be afflicted by this strange illness?
Representative Callahan, humility has been a core personal value of mine since for my entire adult life. So I take this as a position of significant trust and responsibility. And to echo comments that have been made before, I'm mindful that whoever's in the role of judge, they represent justice. And that can't be about the individual or their personal ego. It has to be about the way the system is experienced by the litigants and attorneys that appear before it.
I appreciate your answer, Mr. Thomas, and just please remember that people who come before you, employees, attorneys, and defendants, are quite intimidated by the position you will hold. So thank you very much for your thoughtful answer.
Thank you, Representative Callahan.
Further questions or comments from the committee? Further questions or comments? If not, Attorney Thomas, congratulations on your nomination and best wishes to you.
Thank you very much.
All right. The final nomination we have for review today is David Zagaya of Wethersfield.
you'd raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. Whenever you're ready.
Good afternoon. Chairman Winfield, Chairman Staffstrom, ranking members Kissel and Fishbein, and all other distinguished committee members. My name is David Zagaya. I am extremely grateful and honored to be nominated by Governor Lamont to be a Superior Court judge. If approved by this committee and ultimately by the General Assembly, I will work to the best of my ability to justify the confidence placed in me to be a judge. I am the youngest of 4 children born to 2 loving parents. My mother and father are both deceased, my mom having died less than a year ago. I am sure they are quite proud of their son. We were raised in a loving, supportive home where we were taught to work hard and achieve what we aspired to. My smarter older brother is a surgeon in Chicago. I was born, raised, and educated in Hartford. I graduated from Trinity College and UConn Law School. I ventured beyond the city limits educationally, studying for 1 year in Valencia, Spain, as I was a Spanish major at Trinity. I am fluent in Spanish and continue to maintain close relationships with people I met in Spain almost 40 years ago. I am married to my beautiful wife, Amy, for 23 years now, and we have 3 wonderful children, Sophie, who is at UConn, Ella at Springfield College, and our high schooler, Gabe. I began my professional career in New Britain as an adult probation officer. My years at probation were formative for my future legal endeavors. I immensely enjoyed working with individuals assigned to my supervision, and it opened my interest in the larger criminal justice setting. I soon was enrolled at UConn Law School evenings, graduating in 1993. I continued my career of public service, becoming a prosecutor at the Hartford Courthouse in 1996. I am currently a supervisor in the same office, while the majority of my career has focused on litigating serious felony matters. I truly believe that I have been a more well-rounded and effective prosecutor following my years as a probation officer. The experience enabled me to better understand the various vantage points of accused individuals, victims, and communities at large. That wider understanding of the criminal justice landscape better provided me with the tools necessary to evaluate cases and always strive to be fair and impartial to all individuals I worked with. As I hopefully embark on this new chapter of my career, I am constantly mindful that the best judges that I had the honor of appearing before were the ones who displayed the utmost impartiality and respect to all individuals involved. When that is achieved, there is a certain sense of confidence in the system necessary for maintaining trust. I only hope that I can emulate those mentors in achieving that goal. I wish to thank the many, many individuals, both professionally and personally, who have supported, encouraged, and taught me countless lessons that will surely influence my performance as a judge. I would certainly not be here without them. I believe I have the temperament and experience to serve the citizens of this state as a judge of the Superior Court. I respectfully request this committee's approval, and I welcome any questions you may have. Thank you.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Attorney Zagaya, congratulations. Again, an interesting career path. I think having to go to law school at night and juggling everything else at the same time will give you an interesting perspective, certainly an empathy and sympathy to those that are juggling multiple different things in their life and trying to better their lives. My first question is, have you ever run for elective office?
I have not.
Okay. And how long have you been on the approved list of nominees?
2010.
So another 12 years.
Yes.
So it's been 12 years.
Yes.
Okay. Well, I just think that, again, I think it's some benefit to have court experience as a state's attorney. Not necessary for what it's worth for those watching on CTN. I personally, and I think my colleagues as well, value diversity in all its stripes and colors. And that means geographical, it means race, ethnicity, gender, all of that list of itemizations, but also as different forms of practicing law. Certainly we have excellent jurists who've never been in a courtroom, but are just very smart, very personable, very down to earth, and they can handle their assignments. But I think your background will bring another element to that. And congratulations. I know you're going to be a wonderful asset to the bench. And thank you very much, Chairman Staffstrom.
Thank you, Senator.
You're welcome.
Rep. O'Day.
Thank you, Mr. Chair. Attorney Zagaya, congratulations on your nomination.
Thank you.
You've heard my robitis question that Representative Callahan has asked as well. Based on your opening remarks, I know the answer, but just for the sake of the rest of us, could you just assure us that you would not be afflicted with robitis should you be placed on the bench?
I can. By example, however, I would like to indicate that it's very important to mindfully understand the importance of being a prosecutor. And I've done that for 25 years. And I think one of the important skills that I developed was understanding that the process wasn't about me. The process is about doing the right thing, getting it done, and working fairly and equitably with all parties. And I think once I understood that it isn't about me, I can hopefully properly represent to you that as a judge, I would understand that the process is not about the players. It's about what we're doing. And I feel comfortable in my ability to not be afflicted by that ailment.
Thank you for that response. And are you willing to work at least 9 to 5 anywhere in the state, even as far away from Wethersfield as Stamford, Connecticut, if so assigned?
Yes, I do.
And you've in looking at your experience, you've been with the essentially with the public defender's office and then the state's attorney's office since really looks like 94, 95. You've probably heard me ask the question about continuances. And while my concern is really about even the smaller practitioners who can't be 2 places at once, if and not having that private practice experience, I assume you would be willing to take a look at each continuance request and measure it on its reasonableness and taking into account the fact that some smaller practitioner or smaller firm practitioners may have a bigger problem adjusting their schedule than a larger firm?
Most certainly. And as my 2 predecessor prosecutors indicated, we work with a lot of solo practitioners who can't be in 2 places at the same time. But beyond that, I was a solo practitioner for 1 year when I was looking to obtain a steady job. And having suffered through that year, I know what it's like. And I fortunately have never forgotten that experience.
Excellent. Thank you very much for those responses. Best of luck to you in the process. And thank you, Mr. Chairman.
Thank you.
Representative Callahan.
Thank you, Mr. Chairman. And I'm sure you're not surprised you saw my hand go up for this nominee. I appreciate you coming in today, and congratulations to you and your family on your nomination, sir.
Thank you.
You have certainly worked both sides of the line of scrimmage in the courthouse. You've been in the defense, the state, and as you may know, I worked for probation for many years. So you certainly do get to know every aspect of the court and the inner workings of the court and how the staff affects the daily flow. So I am happy to see someone like you who's come up through the system and worked several different jobs in the court, who I know will make an excellent judge. And I wish you luck through the rest of the process. And it was good to see you here today.
Thank you. I appreciate that.
Further questions or comments from the committee? Further questions or comments? If not, Attorney Zagaya, congratulations and best of luck to you.
Thank you very much.
All right, that concludes our nominees for review. We do have some members of the public who have signed up to testify. Just as a review of our rules on that, I will call on the individuals. They will be permitted 3 minutes to testify. And then if the members have questions, they can follow up after the 3 minutes. All right. First up will be Alexander Tubes.
Thank you, Representative Staffstrom and members of the Judiciary Committee. My name is Alexander Taubes. I am an attorney in New Haven, Connecticut, and I am here today testifying on behalf of my client, Corey Turner, who in 1997 was wrongfully convicted of murder and is currently serving a 60-year prison sentence. Just because a case has been rejected on appeal multiple times, or it's fallen through the cracks of our criminal justice system, that does not mean that it no longer matters. And just because time has passed, that does not mean that a wrongful conviction is no longer serious. Many people have been exonerated in the United States and in the state of Connecticut after many, many rounds of appeals have been denied. For 25 years, Corey Turner has maintained his innocence. A federal judge ruled in Corey Turner's case that the evidence of Mr. Turner's guilt is, quote, not overwhelming, unquote. However, as that judge ruled in that habeas, his conviction has stood because the jury decided in his case against what Mr. Turner testified was his alibi. Then State's Attorney Joan Alexander accused Corey Turner of fabricating his alibi over a recorded prison call. He said that Mr. Turner told Fonda Williams what to say and offered to pay her for it. But after making those false accusations of Corey Turner, then State's Attorney Alexander objected first to Mr. Turner's lawyer even hearing the call, and second, successfully got the entire recorded prison phone call excluded from evidence. The jury never heard any part of that call. If the jury had heard that call, and I have provided that recall to the members of this committee by email, they would have heard that Mr. Turner never fabricated his alibi. He never attempted to influence what Ms. Williams had to say, and he did not offer to pay her for her testimony. The jury never got to hear this. And later hear this because his own lawyer turned on him after the trial and refused to back Corey and refused to state what is obvious, what you will hear when you listen to this call, that it would have helped him establish his alibi and that the jury's decision-making was corrupted by the failure to have this information. I see that my time is running out, but I am willing to answer any questions that this committee may have regarding this miscarriage of justice. A prosecutor is more than just a lawyer. They are a minister of justice, and their duty and obligation to ensure that justice be done extends beyond a conviction, and it extends as far as a person who is wrongfully convicted may be in prison. Thank you.
Thank you. Representative O'Day. Representative O'Day, do you have a question or is your hand still before? Let's go with Senator Anwar.
Thank you, Mr. Chair. Thank you, Attorney Tobes. I had a chance to have a conversation briefly with the judge today, and I know one of my legislator had asked if she had recalled if the jury had a chance to listen to the call, and she was not sure if that was the case. So you're saying that the jury was not able to listen to the recording?
That's correct, Senator. At then State's Attorney Alexander's objection, the judge sustained her objection and refused to allow the jury to hear any part of this phone call. But at the same time as then State's Attorney Alexander denied the jury the right to hear this call, she claimed that on the call, Corey alibi was offering to. So the jury did not have the fair opportunity to determine whether or not Corey was telling the truth and whether or not Fonda was telling the truth. And Fonda is here today as well to testify. And the reason why this is a problem is that as federal judge Shotney held, the evidence of Mr. Turner's guilt was not overwhelming. And the key question in the case was whether or not Corey was telling the truth about his alibi. It has been the law since 1987 in Connecticut that a prior consistent statement is admissible to rebut a claim of recent fabrication. Then State's Attorney Alexander accused Corey Turner of fabricating his alibi over this phone call, but then refused to allow the jury to hear that phone call so that they could determine whether or not Mr. Turner was telling the truth, that he never tried to influence Ms. Williams's testimony, or whether he was lying, as they ultimately determined based only on the one-sided statements of then State's Attorney Alexander and not having the call itself to listen to in evidence as they should have.
I just want to mention that essentially all the people that Judge Alexander has worked with have looked at her as a very fair, very considerate, deliberative individual. And how come at the time when she was nominated and confirmed and has been renominated in the last many years, this has not come out? Why are we having the conversation at this time? Do you have an insight into that?
Yes, Senator. Shortly after, so first of all, I will say this, a prosecutor has an obligation regarding their cases even after a conviction. So Brady versus Maryland requires turning over exculpatory evidence even after a conviction has taken place. At the time of Mr. Turner's trial, then State's Attorney Alexander was not the only person who did something wrong. Mr. Turner's attorney at that time also failed to raise the correct grounds as to why then State's Attorney Alexander was wrong. And following the conviction, there was a procedure called a habeas corpus action that was brought in the court. And when Mr. Turner's attorney was brought before the habeas in 2002, he said he listened to the call, and if anyone heard the call, they would see that it hurt Corey Turner. And on the basis of that, his habeas corpus was rejected. However, Mr. Katz, the attorney, 15 years later in 2017, recanted his prior testimony. He stated that he had made that prior testimony defensively to protect himself, essentially throwing Corey Turner under the bus. And that indeed, if, as any of you committee members could listen to this call yourselves, you also have the chance to hear from Ms. Williams. If they heard that call, they would know that in fact, Corey was telling the truth and never attempted to influence the testimony of Ms. Williams over that call. But in that 2017 proceeding before Judge Westbrook ruled that by the time Attorney Katz had recanted his prior statement, too much time had elapsed, and she no longer had jurisdiction to rule on this. Corey Turner was not aware that Judge Alexander had been elevated to the appellate court. He had not heard that. She had become a judge very case when it was still being appealed and it was still in court. This is the first time that Corey Turner has been able to bring this issue out to a greater light, out to a public light, because it was only in 2017 that his attorney finally came around and admitted what he had done wrong. But at that point, it was too late for him to be able to press his claims in court. So now Corey Turner sits serving a 60-year sentence, a life sentence, And as Judge Alexander stated in her testimony, this is not newly discovered evidence. The phone call, although it was never heard by the jury, in existence at the time of his trial. So Corey Turner is left a man without the legal recourse. And the reason why this is important, even if there is not a single other case that demonstrates this kind of behavior, you have to understand a few things. First of all, this is a capital case. And in a capital case, the prosecutor has an even higher obligation, not just to the victims and to getting a conviction, but to justice and ensuring that justice be done. William Blackstone once said, we'd rather let 100 guilty men go free than put one innocent person in prison, let alone for life. And so what I say, quite frankly, is this case implicates Judge Alexander's character and fitness to be on the Connecticut Supreme Court, regardless of her record in other cases.
Thank you for your testimony. Thank you, Mr. Chair. Thank you.
Thank you. Just real briefly, so the defense counsel at the trial level had access to the tape, correct?
Initially, no. Initially, when it was referred to by Judge Alexander, then State's Attorney Alexander, he asked for the tape. Then State's Attorney Alexander objected to counsel hearing it. The judge overruled that objection. After he had a chance to hear it during the trial, he then for it to be entered into evidence. And that is when the judge sustained then State's Attorney's Alexander objection to the jury hearing it.
But before the case went to jury, the defense counsel did have the tape, correct?
And he sought to have it admitted, and that was overruled by Judge Alexander's then objection.
Right, but the decision to keep the tape from the jury, yes, Judge Alexander made an evidentiary objection, but the ultimate decision to exclude the tape from being heard by the jury was the trial court judge, not Judge Alexander, not then State's Attorney Alexander, correct?
Correct. The judge sustained her objection.
Representative Dubitsky?
Thank you, Mr. Chair. I think you were going the same place I was thinking of going.
Thank you, Representative.
It was the trial court judge who made the decision, not the state's attorney at the time, right?
The judge sustained then State's Attorney Alexander's objection to the jury hearing the tape.
Okay, and who was the trial court judge?
The trial court judge was Koletsky.
Koletsky? Okay, and it's your feeling that the state's attorney should not have objected?
Correct. But that was really just this one of the problems. I mean, first of all, the state's attorney knew that the false narrative that she was pushing, the false accusations she was making against Corey Turner were false. If you hear the tape, you'll see it for yourself, Representative Dubitsky. And as a minister of justice, you have an obligation at all times never to imply or cause an inference to be made that is false about facts, particularly things that are not going to be put in front of the jury, but also things that may be put in front of the jury. And so it was first by, and I can explain to you, first by implying that Corey Turner told Ms. Williams, it would have been sweeter if you had not told the prosecutor that he carried a gun prior to the case. If you listen to the tape, that's not at all what Corey is saying to Ms. Williams. In fact, they are talking about how important it is for her to tell the truth and how he would not ask her to lie to the prosecutor. Second of all, she asked Corey if he had reminded Ms. Williams about the date of the crime. Again, if you listen to the tape, you will see that that is absolutely not the case. And then third, Attorney Alexander asked Corey if he had offered to pay Ms. Williams for her testimony. And once again, if you listen to the tape, you will see that this false narrative is not true. And finally, during the cross-examination of Ms. Williams herself, the alibi witness, Ms. Williams had said during her testimony that she remembered the date because she had gotten up really early that morning to go to work at Cheese and Stuff, where she had begun working. And Attorney Alexander had introduced evidence to show that at the time of the murder, Ms. Williams had not yet begun working at Cheese and Stuff. And so Attorney Alexander began to imply that Corey Turner told her to say she was working at Cheese and Stuff, and that's how she remembered that she was working at the time of the incident. But again, if you listen to the tape, you will see that on the tape, Fonda Williams is not sure that she was working at Cheese and Stuff at the time of the incident. She only remembers that she was working at the time. Now, Joan Alexander had heard that tape and she knew that. But at the same time that she was objecting to the jury hearing that tape, she was implying something else about what the contents of that tape actually contained. And that is worse than simply objecting to the tape being heard by the jury. That's misrepresenting the circumstances in a capital case
And those
for which an
statements
individual is serving a life sentence.
Those statements were before the jury?
Attorney Alexander's cross-examination of Corey Turner, her cross-examination of Fonda Williams, and her statements about the tape during the closing argument were in front of the jury. But the tape itself was kept from the jury.
Gotcha.
And so all they had were the insinuations about what was on that tape. He must be lying. He called her up a day before the trial to tell her what to say. But if you listen to the tape, that's not at all what happened. And Mr. Turner stays in jail because the jury decided he was lying about his alibi and that he was telling Ms. Williams what to say on that tape that they never got to hear.
Understood. Okay, thank you very much. Thank you, Mr. Chairman.
Yep. Further questions or comments from the committee? If not, further questions or comments, Representative Fishbein?
Thank you, Mr. Chairman. Sir, I'm just having a problem with you answering questions and not answering questions. So you were asked a question before. How come this didn't come up when Judge Alexander got elevated to the appellate court in 2016? If you could just answer just that question, please.
Mr. Turner was not aware that Judge Alexander had been elevated to the appellate court until I told him that. And he had no knowledge she had been elevated to the appellate court. So he had no opportunity, and his family, which has been waiting all day as well to testify, had no opportunity to comment on that.
So the only person that maintained this for hearing today was Mr. Alexander at that time, possibly, and not yourself or anybody else.
I'm sorry, I don't understand your question.
I think I got the answer, so thank you.
Further questions or comments from the committee? Seeing none. Thanks for being with us, Attorney.
Thank you.
Next up will be Omar Green. Omar Green. Denisha Spearman. Denisha Spearman. Christopher Turner Williams.
Hello. Hey.
So your camera's turned off. I don't know if you can turn it on or if you want to, but there you go.
Hey. Hello, everyone.
Go ahead, sir.
Yeah, so I am the son of Corey Turner. I just came to speak out in opposition of Jones Alexander in regards to her falsely accusing my dad of being put in jail, honestly. So, yeah, I'm just going to read out to that. Chairman Winfield, minority leaders, gentle ladies and gentlemen of the Judicial Select Commission. My name is Christopher Turner Williams, and I'm here to speak in the opposition of Judge Alexander. The reason for the opposition is simple. During Alexander's time as an assistant state attorney in the Judicial District of Hartford, she secured a murder conviction against my father, Corey Turner, and uncles Charles Turner by falsely accusing him and my mother, Fonda Williams, of fabricating their alibi testimony during a recorded prison phone conversation, an allegation she knew to be false, a decision that she decided to make despite her allegations not being true. In particular, my father, Corey Turner, and Uncle Charles Turner were arrested and charged with August 11th, 1995 for the murder of Richard Woods. My dad, Corey Turner, My dad, Corey Turner, presented an alibi that during the time of the shooting that he was at my mother's apartment. My mom also testified corroborating with my dad's testimony. Despite this, Joan Alexander actively worked to discredit my parents' testimony. During her cross-examination, Assistant State Attorney Alexander accused my parents of fabricating their testimony during the recorded phone conversation, which took place in July 29, 1997. Specifically, Alexander claimed my dad offered to pay my mom for her alibi testimony and that he told my mother she should have lied to the state's attorney investigator about seeing him with a gun in the past. Alexander also stated that my father had to remind my mother of the day of the shooting, which wasn't the case at all. You can clearly hear in the audio that my mother recalled these events on her own, as I have listened to it myself. Despite Alexander knowing the truth, she actively worked to deceive the jury by making false claims against my parents. She then objected to my dad's attorney being allowed to hear the tape recording. After the judge overruled that objection, Alexander was successful in having the recorder excluded from evidence as a prior consistent statement. Knowing the tape recording was consistent with my parents' trial testimony, Alexander couldn't allow the jury to hear the audio, as it would depict evidence that Alexander's claims were fabricated. She took advantage of the fact the tape was excluded from evidence in her closing arguments to the jury by restating her false claims of fabricated alibi. Again, pushing the deception and corruption in what is supposed to be a fair justice system. I'm not going to ask this committee to take my word for any of this. That's why, in support of my testimony here today, I'll be submitting a memorandum of facts along with relevant transcripts for Corey Turner's trial and a copy of the tape recording itself, so that this committee can compare and contrast Alexander's claims of her fabricated alibi with the phone recording conversation to determine for itself the truth. I'm confident upon doing so, this committee will conclude that then Assistant State's Attorney set out to and in fact corrupt the jury's fact-finding process when it comes to their appraisal of credibility of Corey Turner's alibi defense. That in doing so, Alexander violated her oath of office by engaging in conduct that was calculated to produce prejudice and a wrongful decision by the jury. In a capital case where the rest, where my father's life was at stake, that her conduct during Corey's trial my father reflects adversely on her trustworthiness, character, and fitness to be a lawyer or a member of the judiciary. I mean, what criminal defendant on an appeal before the Supreme Court can have any confidence that he or she can get a fair hearing of their case when one of its justice deliberately corrupted jury's deliberation to the capital case to secure a murder conviction and life sentence under false pretenses? Alexander appointment to the state Supreme Court will undermine the public trust and confidence in the fair and impartial effectiveness of the judiciary. For these reasons, I urge the committee to vote no for Judge Alexander appointment to the state Supreme Court.
Thank you, sir. Questions or comments from the committee? Representative Porter.
Thank you, Mr. Chair. And I don't have any questions for you, Christopher. I just wanted to say thank you for coming before this committee and sharing that information with us. It is not falling on deaf ears. I will definitely take into consideration all that you and Attorney Thomas has brought to our attention thus far. And if this is the case, I am truly sorry.
Thank you. I appreciate it.
Know what it is to grow up without a dad. So thank you for having the courage to come before us and tell your story and contribute your lived experience to the impact. Thank you, Mr. Chair.
Thank you, Representative Porter. And let me certainly echo that. I think as was said at the very beginning, I think by Judge Alexander herself, murder trials are a tragedy for all involved. For the victim and certainly for the accused and the family of the accused as well, when someone does go to prison. So we appreciate your advocacy on this, and certainly we will take seriously any materials you send to the committee. Further questions or comments? If not, next up will be Fonda Williams.
And I just want to speak to that. Sorry, not to interrupt.
Just
my mom.
Is your mom going to testify? Okay.
She will not be able to testify today.
Okay. Well, please give her our best. Next up will be Christopher Stone. Christopher Stone with us. One last call for Christopher Stone.
Mr. Chairman?
Yep.
Yes, I'm here. Sorry about that.
Okay.
I have 2 mute buttons on my system and I only pressed 1, so I apologize. Good afternoon, Chairman Staffstrom and members of the Judiciary Committee. My name is Chris Stone. I am a lifelong East Hartford resident and I practice law in the city of Hartford. In the early, I'm here to testify in strong support and the recommendation of Attorney Scott Chadwick to the position of Judge of the Superior Court. I was fortunate enough in the early 1990s to meet Scott at a political function. I've known him now for over 25 years, and he and I were law partners for approximately 25 years or so. As a general practitioner, Scott has a broad understanding of the law. Over the years, I've witnessed not only his legal ability, but also his ability to effectively communicate with his clients. Scott possesses an extraordinary work ethic, whether in private practice, as counsel to several governmental entities, as a DMV commissioner, or as the East Hartford Judge of Probate. When there's a job to get done, he got it done. Oftentimes, I would see him writing a brief or a decision immediately after a hearing. He has the understanding that litigants are entitled to timely, thorough decisions, and I'm confident that he will display that same work ethic as a Superior Court judge. There was a question asked earlier by one of the representatives about judicial temperament. I can tell you that knowing him as I do, he certainly has the proper temperament to serve as a judge. Witness the fact that he put up with me for 25 years. Scott has served his community and the bar extremely well. I'm confident that he will continue to do so if he is confirmed. I want to thank Governor Lamont for putting Scott's name forward. I'm honored to support him and urge this distinguished committee to do the same. Thank you, Mr. Chairman.
Thank you, sir. Seeing no questions or comments from the committee, we appreciate you being with us.
Thank you, sir.
All right, that is the last we have on our public speaker list. So, Madam Administrator, unless I'm missing anything, which I am not, I am going to declare this public hearing closed. I'm going to convene the Judiciary Committee meeting for Monday, April 25th, 2022. And the committee is going to stand in recess for what I hope are brief caucuses. And we will announce the time to reconvene shortly.